I am for the petitioner. 13. I am for the petitioner file affidavit in reply. That is required to be.
You will file affidavit in reply.
Therefore, this people.
You have informed the other side.
This is a requisition to bring the record. Other side receive the copy. This requisition is to be allowed.
What item you said? What item number?
13.
13.
Yes, one affidavit in reply filed by the petitioner, copy already been served. That record is to be bring on record.
Acha, you have filed the reply.
Yes. So requisition is due. Let's me go.
Simple.
May I please, Your Lordship. Item number 5, Lordship. Preparing for the petitioner, we need to file rejoinder, Lordship, but due to some medical emergency, he's out of station, Lordship. So this matter may come after vacation.
Miss S. Kanungo, learned counsel for the petition, submits that she needs some time to file the rejoinder affidavit. There is a law. List this matter after. List this matter on 29th
29, Lordship. Yes.
29th of April.
April, please.
Let me go. My lord, with the consent of others, I beg to mention item number 46, my lord.
46.
My lord. This matter may not be taken today, my lord. It may be taken on, my lord, 8, my lord. 8 April, my lord.
You are for the petitioner?
Yes, my lord.
And A. Manna.
Yes, no. For the petitioner.
Yes, Mr. A. Manna, learned counsel for the petitioner, submits that the matter may be taken up on a later date. Prayer is allowed. List this matter on
8, my lord. 8.
8th of April. 8th of April.
Obliged to, my lord.
Balas in supplemental list item 44, my lord.
44.
Balas.
Okay.
With the consent of other Balas, perform this there.
You are for the petitioner? Yes.
We have to respond, madam. We need some time. After 6 weeks, madam.
Mr. A.K. Sahawala, learned counsel for the respondent, prays that the matter may be taken up on a later date, which is not objected to by the learned counsel appearing for the petitioner. Prayer is allowed. List this matter.
Madam, date may not be given because we have gone to the revision bench. So sometime.
List this matter after 3 weeks on a date.
4
to be fixed. After 4 weeks on a date to be fixed by the registrar.
Much.
In respect of item number 14, I am for the petitioner. The respondents, they have filed an additional affidavit yesterday. I need to file a reply to that. I pray for 3 weeks time.
Which item you said?
Item 14,
14.
on behalf of the petitioner.
Mr. D. Nat, learned counsel for the petitioner, submits that the respondent has filed their affidavit in opposition.
An additional affidavit they have filed. Earlier they
Has filed an additional affidavit to which he seeks some time to file the rejoinder.
Proceed.
Prayer is allowed. List this matter on.
After 3 weeks, no, the
List this matter on 4th of May.
4th of May. Logical.
That is. Also, I beg to mention item number 48 also.
48.
Yes.
Supplementary.
Yes. In this matter, APSC has filed their affidavit in opposition yesterday also. So we may be according 2 weeks time to file our rejoinder affidavit also.
Okay. Heard, Mr.
And I am Ajay.
Annie Majarmia, who submits that the APS, the respondent has filed their affidavit in opposition, to which he would like to file the rejoinder affidavit. And as such, seek some time. Prayer is allowed. List this matter again on.
After 2 weeks.
List this matter again on 24th of April.
Obliged, Lord.
Yes.
With the consent of the other side. I beg to mention item number 25.
25.
I'm on behalf of B. Chaudhary, respondent number 326. B. Chaudhary has had personal difficulties today.
25 you said, right?
Yes, ma'am.
Okay. Hello, Mr.
W. Hada.
W. Ahmed, counsel appearing for Mr. B. Chaudhary, submits that B. Chaudhary is indisposed today and has prayed for some time. Prayer is allowed. Have you informed Mr. Dida, senior advocate?
Can it be on 23rd?
List this matter on 23rd of April.
Ma'am, please, I beg to mention item number 8.
Eight.
8.
Yes.
Actually, today I received the affidavit of opposition filed by the respondent number 9. He is present to counsel. With to reply
You, Mr.
and can.
NK Neo, learned counsel for the petition submits that respondent number 9 has filed the affidavit in opposition to which he would like to file his reply and has wait for some time. Prayer is allowed. List this matter.
The first week of May.
List this matter in during the first week of May. Use this matter on 6th of May.
Public.
With your lordship. With the consent of the other side, declaration item number 36 of today's list. 36. 36. The department has already recorded an appeal which is fixed before the division bench on Monday, lordship. Your miss? Your
After 2 weeks.
is your miss? MM Kotoki. MM Kotoki. Learned counsel for the petitioner. Oh, respondents. Respondent submits that an appeal has been filed against the order for the which is pending before the honorable division bench, and as such, prays that the instant matter will be taken up on a later date. Prayer is allowed. List this matter on 30th of April.
Yeah, please, Malu. Malu, I'd like to mention item number 4 of the daily list. Yes, with the consent of the other side, Mr. M. Sarani, I'm appealing on behalf of him who is out of station. So matter will be taken up after 2 weeks.
Yes, Mr. Rao. Are you a Mr.?
And go with.
Mr. N. Gogol, learned counsel appearing on behalf of Mr. M. Savania, learned counsel for the petitioner, submits that Mr. M. Savania has some personal difficulty and has prayed for some time. Prayer is allowed. List this matter after 2 weeks. List this matter on 22nd of April.
I would mention item 19, lordship.
19.
Yes.
Okay.
This matter has become enforces, lordship.
Okay. Your miss?
M. Borough.
Miss M. Borua, learned counsel for the petitioner, submits that the matter has become infructuous and prays the same may be closed. Prayer is allowed. The matter is closed as infructuous.
Your lordship, I beg to mention item number 1. My senior is out of station, so kindly pass over the matter for the day and
Your senior is Mr. H. Rama.
R. Sharma petitioner.
Ashrama. Your miss?
S. Kulita.
Miss S. Polita, learned counsel for the petitioner, submits that the conducting counsel has some personal difficulty in doing the matter today and has prayed for some time. Prayer is allowed. List this matter after vacation. List this matter on 22nd of April.
Your lordship, I should be the consent from the other side. I go to mention item number 22. Agenda letter
For today,
Let it come after the PU lordship and on behalf of VNAT.
may you miss?
HK Sumi.
H.K. Sumni, learned counsel for the petitioner, submits that the matter may be taken up on a later date. Prayer is allowed. List this matter on 29th of April.
Lordship.
Item number 33, this is a contempt petition. Pendency of the contempt petition, my lord. Speaking order has been passed. The contempt may be closed with a liberty to challenge this order. That may be.
You are for the petitioner.
Yes, ma'am. Answer, ma'am.
Let the matter read and see what is this petition order.
May I please, lordship, with the consent of other side, lordship, I beg to mention item number 23. Here, lordship, I am filing my affidavit today, lordship. Because I have taken the. Yes.
Mr. S.S. Roy, learned CGC, submits that he has filed his affidavit.
Will file during the course of
He
the.
will file his affidavit during the course of the day. And as such, a prays for some time. Prayer is allowed. And the same is not objected to by the learned counsel appearing for the petitioner. List this matter again, and you'll also like to file reply or not?
Yes, yes, ma'am.
Who also submits? Learned counsel for the petitioner, who also submits that he needs further time to file.
I don't need time, actually, no. No, I don't need time.
At least this matter which is considered, which is not objected to by the list this matter again on then after vacation.
After
List this matter on 30th of April.
Apply.
Last time, I think finance was not shown in the cause list file. You need to file affidavit or what?
No, Lordship,
Things are complete.
in fact, Lordship, we have deposited, the amount is deposited before the treasury. So treasury is to release.
You are 44 months.
I'm for irrigation, Lordship. So my client is.
Some time manner to get the instructions, minor. So we are awaiting the instruction.
Otherwise, you said that the money has been deposited, is that?
Yes, Lord, before the treasury, Lordship.
Ah.
This before the treasury.
May please, your lordship, this is a payment of his NPS own subscription. Because when he was not allowed for pension under 1969 scheme, that he was he was instructed to contribute for NPS. So this is his own
Lordship,
contribution.
there is no dispute.
Uh,
There is no dispute. Already amount has been submitted to the treasury. So treasury is to release to the petitioner. Now, my client will be paying stuff.
Instruction to the effect that when will it be released or whether it has been released?
Lordship.
The proposal has gone, I have just gone for the instructions provided to my learned colleague. It says, my lord, that the proposal has gone to the Director of Accounts and Treasuries. Now, what has happened thereafter? The Lordship
Proposal has gone to make the payment.
Yes, my lord. For regarding proposal for drawing up NPS contributional amount from tier 1. So, my lord, under the new pension scheme, my lord, both the employer and employee both have to make contributions. Now, once my lord is out of job or is the requirement of money, the employee concerned, my lord, then the proposal will have to be routed for the Director of Accounts and Treasuries. Now, in the case, my lord, where from the document I find, my lord, that the proposal has gone to the Director of Accounts and Treasuries. In also will please accommodate me for some time, my lord, I will get the instruction. So let it come, my lord, next week, my lord.
Heard Mr.
GR Dev.
G.R. Dev, learned counsel for the petitioner, and Mr. Upadhyay, you are for,
Irrigation department.
and Upadhyay, learned standing counsel irrigation department, and Mr. Paul Pujari, right?
Is for 6 Lord.
Pujari,
For 6.
learned counsel for the finance.
Lord.
Mr. Paul Pujari submits that the proposal has been forwarded to the accounts and what do you say?
My lord, it is the Director of
Director
Accounts
of-
and Treasuries,
Director of Accounts and Treasuries,
Assam.
Assam,
My lord, on, that is my lord, on 28th of November, 2025.
on 28th of November 2025.
My lord.
And that he requires some more time to get the instruction as to whether the contributions has been paid to whom? To the petitioner.
To the petitioner, whether, my lord, what is the stage of the proposal, my lord?
Oh.
And my lord, what is the consequences of that proposal, my lord?
In order to find out what is the stage of the proposal and the consequence thereof.
I know.
Prayer is allowed, list this matter accordingly, list this matter on 7th or 8th of April.
8 of it.
Yes, my lord.
8th of April.
Or 7 of it.
8 is the last working
Lord.
day, right? So 7th.
7 of
Seven.
it.
And so apply.
Lord, apply.
Yes, ma'am. Yeah. It's not-
Lordship, in this matter, there are clear direction from this honorable court. Lordship may kindly have a look at the orders. First order passed by honorable Lordship on 31/2026. Lordship, third paragraph. Ms. Bora has submitted that the department is processing the matter for release of notional benefits to the petitioner with effect from 20 to 2019 till the date of his superannuation. Considering the order dated 21/11/2020, the petitioner in the considered view of this court is entitled to all the consequential benefits of his promotion with effect from 22/2019, and accordingly the departmental authorities would now process the matter and ensure that the dues receivable by the petitioner is released to him at the earliest. Then thereafter, your lordship may kindly have a look at the subsequent order passed by this honorable court, my lord. It is of lordship 31/2026.
Department means the transport department.
Yes.
We have filed our affidavit in this matter. Madam, we require some more time. We have sent the file to the personal department. The personal department has sought some clarifications.
They require some more time.
Lordship, what happened?
Notional retirement benefit.
Yes. What happened? Not retirement benefit. My case was that I should have been given promotion from the date my juniors got promotion. To that effect, they have issued the order. But subsequently, what they have done, from the date of my joining, the benefit was given. Not from the date my junior got promoted. Lordship, then now they seek the view of the Lordship Finance Department. I don't know why.
For the finance department, we have
They have to pay. So otherwise, what they say, they admit that
Yes,
you
yes,
have to be
they
paid
say.
from the date of
Yes,
your
yes,
juniors.
yes.
there is the order. So we
You are for the transport
my
department.
lord, I'm
Yes.
And what about finance, Mr. Borchari?
My finance is not a party.
Lordship, they made that submission before the court. Then, but this is a matter relating to 2019, too late of the date, and court said you process what you do.
Yeah.
Now they want to take the views of the finance
What is
department.
the last order?
Lordship, Lordship, it is of 13/2026. Same order, same repetition, man.
We filed our affidavit. Some more time, take time.
You have not filed your
We
affidavit?
have filed-
They have filed. Nothing, I
Some
think,
court
don't.
instruction.
Yes, my lord. We have filed our affidavit, my lord. Subsequently, we have sent it to the personal department. We have moved the file to the personal department. Personal department has sought some clarifications. This will require maybe after the communication by 3 weeks time, I'll be getting on the. This is the-
Lordship, some DP was drawn up against that person for
Against the
overstay.
petitioner?
No, no,
Oh, actually.
against the other one,
Uh-huh.
junior.
Ah.
So, because of overstay,
Mm.
Lordship, so they want to take it to the notice of this honorable court. I think it's not, I need not file my reply to that effect. Nothing is
Let
against
him
me.
come up with the instruction, Mr. From the first.
Fixed date be given, man.
Okay, Mr.
RT Goswami.
I heard Miss B. Bhuya, learned counsel, the senior counsel assisted by Miss Jay Saikya.
Day cycle.
Jay Saikya, learned counsel for the petitioner, also heard Mr.
RT Goswami.
R.D. Goswami, R.B. Goswami, learned counsel appearing for the transport department. Mr. Goswami raised that he may be allowed some time to bring the latest instruction from the personal department, and would also like to file an affidavit.
We have filed our
Let it
affidavit.
file.
Only the instructions. Instructions and has paid for some time. It is instruction from the personal department and has paid for some time. Here is allowed. This matter again on 6th of April.
Lordship, after the.
After
audit.
this.
So the.
Okay.
And it will 27, man,
27
27.
today.
Okay.
On which date he will place the instructions without fail.
Yes,
On which date he placed instruction.
deeply obliged. You have to open.
Mr. Sekya.
We really worship. We have the petitioner before proceeds claiming the benefit of the ROP 2010 and 17. 2010 and 17.
ROP of 2010 and 17.
They will pay their retired employees, my lord. They will pay as per the recommendation of fifth CPC, fifth ROP and
They were getting which ROP?
fifth ROP,
Fifth.
fifth. Sixth and seventh they have not received.
And they retired.
They retire.
They retired after the ROP 6 and
After
7,
ROP 7.
but they were not given.
And government, my lord, the department authority, they come up with a affidavit wherein they say that that is not applicable in the case of the petitioners.
Why?
They say that the
ROP 6 and 7 are not applicable. to
not
the petition.
applicable.
Why do they say that?
They say that they have the also kindly take up their affidavit
Mr. Corporation is there.
Page 58.
Yes, my lord, I am appearing for the finance department. Here, my lord, the administrative department is, my lord, the hill areas department. Now, prior to filing of this writ petition, my lord, the petitioners had already moved this honorable court. And there was a order passed by this honorable court. If lordship may be pleased to come to page, my lord, 31 of the writ petition. That is the earlier round of writ petition. Where, my lord, they had approached this honorable court, my lord, claiming their salaries and other service benefits. Now, page 31, my lord,
Retirement.
my lord,
Before retirement.
before retirement. Now, my lord, immediately, my lord, these petitioners were not government employees. So they were employees under the corporation. And under the scheme of ROP rules, my lord, unless and until the ROP rules are specifically adopted or extended by the corporation to their employees or by the parent department, which in this case is the hill areas department, then, my lord, the benefits of ROP will not flow to the employees, to any of the employees. So there has to be a specific adaptation of the ROP. Now, so far as the earlier round of the litigation is concerned, if for a moment lordship comes to page 31 of the writ petition, my lord, I'm troubling my lord with
Part of the order.
yeah, no, my lord,
Part of the order.
part of the order, yes. 31, my lord, paragraph 9, down below, my lord. My lord, if I may read it, my lord. The submission of Mr. So-and-so, the learned counsel for the respondent five corporation, that the corporation is making some profit and the area salaries of the employees are being paid from such profits to extent possible without compromising with the growth and development of the corporation is noted. It is also noticed that a number of correspondence has been made by so-and-so corporation to the Department of Hill Areas, wherein the corporation has sought the assistance of the state government. Technically, the state government may not be liable to extend financial support to the corporation, but in view of the financial difficulty faced by the corporation, the state government in the Hill Areas Department as well as in the Finance Department may consider extending financial assistance to the extent possible. The corporation shall also continue to pay the petitioners their current and area salaries by devising a method, particularly to clear the area dues in a phased and expeditious manner. So it was basically in the form of a recommendation, advisory by this honorable court. This is not a mandamus per se. Nonetheless, my
They consider.
yes, they will consider.
Mention, okay.
Yes, now, my lord, during the writ proceedings of the instant case, my lord, their petitioners have filed an additional affidavit. If lordship may be pleased to take up that additional affidavit, my lord, it starts from running page number 71.
So the fact is, they are the employees of the corporation.
Corporation, and now, my lord, the development has taken place to the extent, my lord, that the matter was moved to the finance department, and in fact, my lord, the parent department, that is, my lord, the public enterprises department has also taken a call. Now, under the instructions from the finance department, the parent department has to execute a memorandum of understanding with the corporation for, my lord, calling out for calculating the liability and how that liability is going to be dispersed. So to that extent, my lord, whether that MOU has at all been extended or, my lord, it has been executed by and between, my lord, the parent department and the corporation. To that extent, my lord, the instructions has to be, my lord, placed before this honorable court by, my lord, the parent department.
Who is appearing for the
Because
Gauhati was there.
department to say?
parent department, my lord, will have to execute a
No, what is that parent department?
here it is, my lord, the hill areas department.
Hill area.
Hill areas department. Hill areas department is a party respondent. My lord, that is respondent number 1, 2. Now, so far as, my lord, the instruction issued by the finance department in the form of a notification to riddle out the difficulties, my lord, that lordship will find it running page number 89, my lord. It is a part of the additional affidavit. It is a part of the additional.
What is the problem like now? What he is saying is petitioners were not given the ROP 6 and 7.
So therefore,
ROP has to be adopted by the corporation.
That has been extended.
And for the purpose of adopting that ROP, there has to be a memorandum of understanding. Now, whether
Between the parent.
parent
and the
department
corporation.
and the corporation. Now, whether that has been executed or not, my lord, to that extent, my lord, the instructions has to be put. So far as the, my lord, role of the finance department is concerned, that is spelled out specifically at page 89 of the additional affidavit, running page 89. So
What
this
does
is
it
how,
say?
my lord, the finance department has, my lord, devised the scheme. So this is the scheme, my lord. It is under this procedure, my lord, that
Whether it has at all been adopted, that is the main
absolutely,
question.
absolutely.
Yes, Mr. Chutia, are you there?
Yes.
So whether there is a memorandum of understanding,
Page 78, my lord, page 78 has been extended by law.
or it has been extended
Page 78.
by way of an MOU?
This is the notification, my lord, issued by the Commissioner Secretary, Government of Assam, Public Enterprise Department. We are at serial number 7, my lord. Page 78.
Page number, serial number 7,
7, my lord.
Assam State Film Corporation. You are the employee of this corporation.
No, no, my lord, they come under proximity, please to come to
Some,
page 80, my lord.
4, my lord, 4, my lord, I'm sorry, my lord, 4.
Fisheries. No.
Assam Small Industries Development Corporation Limited.
Acha. So you are the employees of this corporation.
My,
And according to you, the corporation has adopted.
my lord, this has been extended by the government, the benefit of my lord, ROP, that has been extended
By the government to the.
by the government to the corporation.
By the hill salients.
By the Public Enterprise Department.
Acha, what are you saying?
My lord, perhaps, my lord, this will be, my lord, and indirect submission with all respect, my lord. My lord, page 78, lordship is in page 78, my lord.
Yes.
There lordship will find, my lord, serial number 4. Some small industries development corporation. They are not the employees of this entity. Rather, they are employees of, my lord. Lordship will kindly see, my lord, page number 80 of that same document. Page number 80, my lord. Page number 80, my lord, serial number 2.
Small Industries Development.
Assam Hill Small Industries Level. They are employees of this entity, my lord. And this notification was issued on 7th of June 2011. It thus lays down the broad parameters without disclosing the exact procedure that has to be adopted for extending the benefits to employees. This is the petitioner. That lordship will find, my lord, at page 82. My lord, my lord, not page 82, I'm sorry, my lord, page 89.
Page 89.
Page 89, which I have just now drawn my lord's attention, my lord, some time ago.
89.
Yes, page 89.
You have just shown me this.
Yes. So therefore, page 78 notification which lays down the broad parameters that was issued on 7th of June 2011. 1 year thereafter, my lord, this notification came to be issued, my lord, at page 89. So therefore, under the notification at page 89, the administrative or the parent department has to execute an MOU. This is the settled position of tax, my lord, no dispute. So whether at all that has been executed, my lord, that instruction may be taken. That is the issue.
That answer I'm not getting whether it has, now he said that it was extended.
My lord, I'm sorry, my lord.
Those were all broad parameters.
All broad parameters, my lord. The crux of the matters lie, my lord, at my lord, page 89. Page 89. Because page 89, after much deliberation, my lord, the finance department my lord, has issued this notification, laying down the procedure, my lord. How it is to be, my lord.
Okay, I'll go into that, but whether it has been adopted, Mr. Chutia.
No, my lord, that is our affidavit also said like that. Our affidavit also can see filed by respondent.
Okay, I'll just go through this page 89 once again.
My lord, sir, paragraph 4. The authority for a state corporation began seek and defer for a period 2001, 2000 to 2001.
Where you are reading your affidavit filed by?
It is affidavit by the filed by respondent number, that is 1.
Respondent number 1. What is the page number?
Joint secretary, page number, my lord, adequate 59.
59, yes. What do you say?
Paragraph 4. The Tripura answering Tripura states that corporation becomes sick and defunct for a period of 2000, 2001 to 2012, 2013 and it is still in revival stage with the limited budget provisions of the government. Therefore, the statement of the petitioner it is functional as well as it must prove. And next, notes is kindly see paragraph 6. Answering the current state that compliance with the Honorable Court's order 19/2019 and subsequent contempt case number so an account of which is 6.34 was released in favor of the AHSIDC Limited.
So this corporation, in view of the High Court's order, some amount has been released.
Released, madam.
And you say that this is sick and defunct, and then it is in the stage of revival.
Yeah, it is not a government service. They are not a government
These
service.
are different issues, but whether this ROP has been extended.
That is not mentioned in our one of the lordship, otherwise, my lordship directed to open instruction in the additional affidavit. My colleague, one colleague, sent a letter, but answer has not come yet, madam. Let it be after deliberation, my lord. In the meantime, I will update the instruction.
Person has retired, not got the revision of pay scale.
My lord, maybe retired, my lord. If it is at all, you should get it, lordship can direct it. But we will have to complete the instruction, madam.
Okay, if that is the clinching issue, then you have to bring the instruction. It's the clinching issue, right? It has to be, the MOU has to be entered into. Otherwise, how will the
I have already received the instruction, madam, on the strength of the materials enclosed to the additional affidavit. Because this is not sprang up because of the additional affidavit filed by the petitioner. My lord, so far as the additional affidavit that has been filed, my lord, I have, my lord, been blessed with the complete instruction. Whatever I have submitted, my lord, this is my instruction. From the instructions I have submitted. So finance department has laid out the broad procedure. Now it will be applicable for so many corporations under the state of Assam. This being one of the corporations, now whether in particular in the present case, my lord, that procedure has been followed for the next level. When I am sitting for the meeting.
Okay, you bring the instruction on the next step. But Mr. I, learned counsel, and Mr. R. Gordon, learned counsel for the finance department, and Mr. T. Tutia, learned counsel, learned government. By this application, the petitioner has prayed for allowing them to receive the ROP 6th and 7th. 6th and 7th.
6 and 7.
6th and 7th ROP. As they were paid only the 5th ROP. It is also stated that the petitioners had in the meantime retired. The learned counsel for the respondents stated that in order to receive the 5th and 6th ROP, 6th and 7th ROP, the requirement is that they call the parent department. Requirement is that a memorandum of understanding has to be entered into between the parent department and the corporation. Incorporating that the ROP would be extended to the employees of the corporation. The instruction as to whether that memorandum has been entered into is not forthcoming. And as such, Mr. T.C. Chutia, learned government advocate, is directed to bring the instruction. Bring the said instruction. Accordingly, list this matter again on 27th of April, on which date the learned counsel will place the relevant instruction. List it accordingly. Okay, you bring that instruction. Mediation report. Mediation report is received. Have you gone through? Paid. Mediation paid. So,
This case, your lordship,
the petitioner in the legal heir of the deceased for the employee.
Oh, whether returns have been filed
No, not.
required. Yes, Mr. Chutia, who are the respondents here?
We have not received instructions, madam.
What is this matter about?
Matter is gratuity and area dues of the deceased father. But they are not released. Page 22, Your Lordship, 22. Letter of the Accountant General.
General Administration, Mr. Chutia, you are appearing.
No, madam, the instruction when I have to form a hearing.
So can this matter be heard today or you want some time?
No, order of one is, which is the purpose to be considered.
Pendency on penalty, it is not released, but other expediting pendency within my case.
See the order, Mr. Chutia, see the order dated 1/3/2023. 2 years back. Right. Here it is said that there is no departmental proceeding going on at present against the father of the petitioner. But then what happened when the father of the petitioner died and the case was abated, there was nothing written in the report that he is relieved of the charges. So they are not releasing the earlier benefits, earlier pensionary benefits and as well as the pension.
Petitioner father died in 2016. Leaving the petitioner to brothers and legal heirs. That is admitted by the additional deputy commissioner by instruction. And regarding release of it, treasury, the finance department is made party.
But then the decision, this is totally on a law point, whether he is entitled to get that.
Yes, lordship by disposal to verify whether he is entitled to pay. Because the study council is not present. And regarding
In absence of the finding that he is relieved of the charges,
Sajid Palat is if there is no Palat, the further proceeding is pending, is released.
abated
Abated, it's expired.
because he died.
He died.
It is abated against
It
him.
is still pending and it's expired.
When
It is
Palat
abated, but then
has to be examined by the lordship, my lord, with the instruction, but we have not received the instruction. So this instruction from the
no instruction, here it's a law point, whether in absence of relieving him from the charges, pensionary benefits can it be given?
that can be given, my lord. But otherwise, nothing against it. Only these charges. Apart from these charges, nothing against you. Then, my lord, entitled. As you, my lord, say, I am to refer to letter of objection. I am to return here with the pensions case in respect of Jyotin Chandra Das, ex-accountant, and to state that the case has been forwarded to this office with a certified copy of Honorable Special Judge CBI Court, where it is stated that proceeding against Jyotin Chandra Das stands abated. However, it is not clear whether the incumbent has been relieved from the charges imposed against him in view of the order. That is the instruction from the accountant general. In view of the above pension case may kindly be forwarded with specific sanction the light of the court. Whether they have said or not, these are the letter written to the deputy secretary of the finance.
So you get the instruction there.
The finance department will get the instruction. Definitely, Accountant General sent it letter.
Finance department just release the amount.
That
Who will take the decision whether to release the amount or not?
is one of finance department, no? He working under treasury office. Treasury office.
Actually, he was under the treasury office.
Accountant
Accountant general will.
General मतलब say like that मतलब treasury office they will say, but treasury तो मतलब तीन आया हुआ है there मतलब treasury
You did not get any reply. Now it is 2-3 years.
the finance department is extending up to the treasury मतलब.
Take after Sunday, I could inform
You get your instructions then.
after some time.
I heard Mr.
Yes.
S.
Islam.
S is learned counsel for the petitioner and Mr. T.C. Chutia, learned government advocate, and Ms. Smith corresponding number 2.
मतलब GAD statement also required because ADC write this letter, they says ballot, it is a here paragraphs comment have already been sent to the city on for advocate Gauhati State Council, General Administration Department in this regard. So General Administration, I will inform ballot to come. He will take up the matter.
By this application, filed under Article 26 of the Constitution of India, the petitioner pays for release of the gratuity and other area dues of his deceased father in favor of the petitioner and other legal aids. It is the case of the petitioner that a departmental proceeding was conducted, not department.
No.
A case of what? A case was registered as Anti-Corruption Bureau case number 14, dated 13/9/1993. Against the officials of veterinary department. These are all veterinary. You said
No, I am the treasurer, that's I am implicated.
you are also
Corruption in the veterinary department, but they have withdrawn from the treasury. That's why
against various officials, against the officials of veterinary department of Border district, and the petitioner's father was also, who worked in under the treasury department, was also implicated in the said case. Full stop. While the case was going on, the father of the petitioner expired
on 14/12/2016.
on 14/12/2016. And due to the death of the father, the said case was abated qua him. Right. Abated qua your father. Abated qua him. QUA. Oh, qua him. However, while abating the case, there is no finding to the effect that the father of the petitioner was relieved of all the charges against him. And as such, the respondent authorities could not process the payments to be made to the father of the petitioner. The learned counsels for the respondents have apprised this court that who has written letter to whom?
My lord, accountant general written to my lord.
Accountant General. Accountant General is respondent.
Respond number.
Accountant General, that is respondent number three, had written a letter to the Finance Department asking for the what? To the Finance Department. As to whether payment to the father of the petitioner can be made in absence of the charge, in absence of the findings that the father of the petitioner was relieved of the charges, to which the Finance Department is yet to reply. As such, the learned counsel for the respondents are directed to get the latest instructions from the finance and other relevant departments and place it before this court on the next date fixed.
Fix the date.
List this matter on when?
Immediately after vacation.
List this matter on 24th of April. Matter has been pending for long, so bring that instruction. Whether this is a simple question, whether he is entitled to get the payment. You just have to see what is the implication of abatement. If a case is abated, whether all the charges get vanished.
Yes, already after date. Electricity is a property of an employee. It is cannot be taken. After release of salary, it is not. These are not the main accuse. Only he simply created that things. And that criminal case is still pending. This is the problem.
But whether you are entitled to get the same or not, that has to be again examined.
Allegation against the veterinary department, my lord.
Ah.
And he was a treasury officer. The excess of the treasury, they have paid the public fund.
Case must be still going on.
So what is his
In this
involvement?
case, it is abated.
Yes, what is involvement? What is the degree of involvement? See,
No, those are not to be seen because abated.
Only abated.
What is the consequence? What is the consequence of abatement? You just see the rules and the law on this. You'll get judgments also.
Whether absorbed his office,
Hmm.
by abating, but whether he's the absorbed from the
Yes, this is what gives some judgments.
Yes.
Further, the learned counsel for the petitioner is also directed to enlighten this court on this law point by bringing some judgments or by referring to certain rules and regulations.
My lord, in this case,
9 and 10.
9 and 10. The petitioner herein is aggrieved by the action of the respondent, whereby they have placed the respondent number 5 above me in the seniority list. That we have challenged, that he cannot be placed above me in the seniority list. I am saying that my appointment is in the year 2018. His appointment is in the year 2019. So he is junior to me. He
In
cannot.
the initial select list, he was junior to it.
I'm coming to that, Your Honor. There is some facts are there. So
Can this matter be taken up today for this?
it has to be admitted. I'm making submission for admission so that it may be fixed for hearing. This matter will require some deliberation. So this matter has to go for hearing.
In Lordship, I'm just praying for a fixed date, Lordship, because the sword is hanging over us.
Anything but
Why again admitted hearing, we can dispose
No,
of.
because
Yeah, the admission still accept, Lordship.
the thing is that 2013 an advertisement was floated. There respondent number 5 was selected. Then the petitioner filed a writ petition before this court, challenging his appointment. Then court said that his appointment is illegal. That and it was cancelled. And in that place, my appointment was directed. Then I was appointed. After my appointment, he again filed a writ appeal challenging the order of the learned single judge. In the writ appeal, the department comes and says, oh no, we have one vacant post. We can give it to him. Then the division bench said, okay, then give it to him. Let him continue. Now, after the writ petition order, he was terminated from the service. Also, High Court single bench order, he was terminated. His termination order was not set aside by the division bench. And the order of termination issued by the department is also nowhere under challenge. So these two holds the field. Then he was reappointed. When High Court said that if one vacant post is there, give it to him. Since he is serving since 2014, just give it to him. And High Court have also mentioned that this will not act as a precedent in any other case. Just for a special consideration when giving to him. Now, our case is that your seniority has to be calculated from 2019, not 2014 when you have joined in the earlier post. Because 2014 you joined, but High Court held that that was illegal, vitiated, then you were terminated. Your next appointment is a fresh appointment. You cannot claim seniority from 2014. Fact being that there are two things acting on field. One is the High Court's order saying that your appointment is illegal and vitiated. And second, the termination order. These two. And there was from the date of his termination, then his reappointment. Immediately after the single judge ordered, he was not terminated, he was continuing. Then petitioner came and filed a contempt case. Then he was terminated. And the gap from his termination to reinstatement is around 14 days. Now, the respondent have invoked such rules, 14.1 of leave rule, FR 85, and have given me extraordinary leave for 14 days. That is also an issue we are bringing in, because we are saying that this extraordinary leave is only applicable to officers or government servants. During that period, since he was terminated, he cannot be considered as a government servant to bring in these rules and give him the benefit. This is our case.
So 14 days was the difference from termination to reinstatement.
Lordship,
14 days he was given on leave.
14 days given extraordinary leave. Then we are saying, no, this is not the main issue. This is one of our issues. Our main issue, which I have submitted earlier, that is our, yes.
He was terminated and his seniority will be counted from the date of rejoining.
Fresh appointment. Date of fresh appointment, because he was appointed to the vacant post, fresh. So fresh appointment. And their case is that in the writ appeal, division bench said, you continue. So that word continue they are pressing. Since High Court says that continue, so it has to be from 2014. This is the entire matter.
Lordship is having item number 9, the Lordship WPC 1452 of 2023. Page number 43, your Lordship.
I'm holding item number 9,
Lordship.
071.
1432.
1432.
1432.
This is the facts. According
Lordship, I
to
think
that
it
is
is a
the facts.
correct perspective, Lord.
So his seniority,
The correct perspective, Lord.
he will be junior to you because he will be rejoining in the year 2016, 19.
Yes.
That is their case, your Lordship. My case is very much evidence on page number 43, as per division bench's order, your Lordship. Page number 43, paragraph 9.
Page number 43.
Paragraph 9.
Yes.
If I may probably to read, your Lordship. In the instant case also, as indicated above, the appellant, that is the Shabha respondent number 4, was appointed as an assistant deputy controller of civil defense junior on being duly selected on merit. And it was not his fault that the respondent authorities had not applied the provisions of the Act of 2005, which otherwise would have entitled the respondent number 1 to be appointed. Paragraph 10. In such view of the matter and as agreed by the party, the appeal stands disposed of by directing the respondent authorities number 2 to 4 to allow the appellant to continue in his service as an assistant deputy controller of civil defense junior by adjusting his service against the available vacant post of assistant deputy controller of civil defense junior, and the respondent number 1 be appointed in terms of the order passed by learned single judge. The aforesaid direction has been issued in the prevailing facts and circumstances of the present case and shall not be considered to be a precedent for any other matter. So this makes the situation amply clearer also. Continue. There's an order, and that is not under challenge. They never went to Supreme Court or higher court to challenge this order.
It was not his fault that the respondent authorities had not applied provisions of
2005.
just 2005 Act. provision.
Reservation.
Women's reservation.
Women's reservation Act.
This respondent, you are a lady.
No, I'm a male lordship.
Uh.
The respondent number one is Ms. Chatter, Mrs. Chatri.
But it was your appeal.
Appeal was my lordship.
Uh-huh.
It was not the fault of the appellant, not his fault. The appellant. That the respondent authorities did not apply the provisions correctly. But whatever may the case may be, lordship, as on date, this order stands. Because they have not challenged us.
You were terminated, right?
My services are coming
You had a single judge's order was also against you.
against me. Lord.
And you had filed the appeal.
Appeal.
And in the appeal, what happened? There was a vacant post and you were directed to be accommodated.
To continue in his service.
To continue.
So breaking service does not arise, your lordship. And in the provisional edition list, in fact, she is number one of 2019. Because I was the previous appointee of 2014. That is how I'm senior to her.
You were appointed in 2014
2014.
and she was 18.
That is the case. So what I propose, lordship, is matter may be taken up for disposal of some other data. Lordship. It should require some time, your lordship, with a two-rate petition. Your lordship.
The point for consideration is that the word continue used by the learned division bench will mean from 2014 or will mean from the date of appointment, which is 9 January 2019.
To continue in his service as and means nothing else, your lordship, other than 24. No dispute regarding that. Sir.
Continue, you see the entire line.
Lord,
The appeal stands disposed of by directing the respondent parties to allow the appellant to continue in his service. In his service. It's not that he was allowed to rejoin his service.
Lord,
Continue in his service as of so and so by adjusting his service. That means he is already continuing, adjust him in the vacant post.
Lord,
So plain reading shows that
Whatever
his service will continue since 14.
final decision has to be taken by the court. I'll try to be very fair here. Kindly come to page 38 for a moment. Page 38.
And what respondent number one be appointed in? Respondent number one was already directed to be appointed by the single judge.
no, which otherwise would have entitled the respondent number one to be appointed.
Respondent number one is he
No, yes, in the appeal, in the appeal.
in the appeal.
Yeah, which
So
otherwise
she-
would have,
Appointed by single judge's order.
lordship, otherwise would have entitled 2014 around. She kept challenging them. Which otherwise would have
In the
entitled.
selection process of 2014.
Not
As she was not selected.
not selected because the Reservation Act was
He was selected.
applied incorrectly by the respondent authorities.
2005 is the Reservation Act.
It was not the reservation.
Acha, acha.
That is the case, Lord.
Now,
By single judge's order in 2016, she was appointed.
and my contention would be kindly come to page 38 for a moment.
Acha, now that we are not taking it to
Lordship.
disposal, right,
Some date in April or May.
we can dispose it of.
No, some date in April or May.
Our prayer, Your Honor, in this case will be the single judge order, para 19. It reads, under the facts and circumstances of the case and a result of the foregoing discussion, the selection and appointment of the respondent number 5 on the basis, that is he, the respondent number 5 on the basis of the select list dated 26/6/2014 is found to be vitiated and therefore the same is set aside. My contention will be his appointment to that post is set aside. And High Court, the division bench has not restored it. That is set aside and given to me. Now I am sitting in that post. Subsequently, he came for writ appeal, and the writ appeal, the department said we have one vacant post, we can offer as on today. They offered it as on that date. He took it in 2019. So I am saying he cannot claim benefit of this post which he was holding and which was held to be vitiated by the court.
The Lordship, just one statement, Lordship, but 38.
I think we have said.
No,
Yes.
it is very, let me just explain. Lordship.
Because when the single justice order was passed, what he was accommodated
No.
in that post.
Correct, Lordship.
So your service is actually gone.
Gone.
Lordship, if I may, her, Lordship, last line, her seniority in service for the purpose of promotion shall be reckoned only from the date of actual service, that is 29/12/2018.
Actual
And
service.
Lordship,
As far as she is concerned, will have to be from 2018.
2018, Your Lordship.
This is made.
Since, because of division by the order,
Jesus.
the
We are
only issue, Lordship, was that they never went up to the higher forum to challenge the same, Your Lordship. The
Lordship.
appeal is not at finality, so there's no dispute regarding this.
And one more very interesting fact, Lordship, last I'm putting up. His appointment letter dated 9 January 2019, reappointment order. As per Gauhati High Court's verdict dated 26/4/2018 and 13/7/2018 against WPC number so and so and writ appeal number so and also by government order so and so dated so and as per Assam Civil's Defense Non-Gazette Service Rule so Diganta Sharma, that is he, address so is hereby appointed as Assistant Deputy Controller Civil Defense temporarily in the office of so pay and allowance so. Last line, the appointment is purely temporary and liable to be terminated at any time without any notice. So, at first place, he should not have accepted this appointment letter. He accepted it 2019, and he's now today, Your Honor. His service as on today is on the strength of this appointment letter. He is doing service now. I'm not challenging. But his service as on today is on the strength of this appointment letter, which is 2019. How can he claim 2014? And if he is given that, then this single judge order is there that is already vitiated. This is the entire matter. So at last, whatever honorable court takes, that will be final. But these parties are fighting on these issues.
At the very first instance, you being a failed candidate, how could you have challenged his appointment selection?
My lord?
You had failed in that selection process in 2014.
No. I did not fail. I was not, as per women's reservation, I should have been selected. But that reservation was not given. I did not fail. I also performed very well. I think I was in the third position. And one OBC candidate took the first position. And I was the third highest scorer. Then he was appointed. 2 posts were there, he was given. Now High Court said, no, you should give the women's reservation. So he was removed. That's why we have not challenged his appointment also. In the writ appeal also, when they said that there is one post, we can give it to him. We were happy with that. But now, problem arises now when his seniority list is given above me.
Okay, heard Mr. F. Khan, learned counsel and Mr. C. Chutia, learned government advocate, and Mr.
And what?
Gautam, learned counsel for respondent number
4 in 1432 and 5 in 207. I'm respondent
Yes.
number 4.
In item number 9, I'm passing this order.
Okay.
Now, 5. The case of the petitioner is that the petitioner was not appointed in view of the selection process undertaken in the year 2014. And respondent number 5 and respondent number 5 was appointed in the said year. The full stop, the petitioner challenged the appointment order of respondent number 5 and not allowing her appointment and for not allowing her appointment by filing a writ petition before this court. And the learned single judge, after hearing all the parties, had held that appointment of respondent number 5 was wrong, and the petitioner, by applying the Reservation Act of 2005,
5.
should have been appointed, and a direction was given for appointment of the petitioner. Agreed by the said order, respondent number 5 filed an appeal before the Honorable Division Bench. And during the pendency of the said appeal, the government, the council, the learned council appearing for the government submitted that there is a vacant post in the said department, and on the said submission, the court directed the department to induct respondent number 5 in the post of, in the
Wait,
post,
say
additional
Assistant Deputy Controller Civil Defense.
Assistant Deputy Controller of Civil Defense Junior. And in delivering the said judgment, it was stipulated that the respondent number 5 would be allowed to continue in his service by adjusting against the available vacant post. By adjusting against the available vacant post. Full stop. Do you have the same? Respondent number 5 was appointed as such in the year 2019. By filing this writ petition, the petitioner, no, before that, no, 89. Thereafter, the department, while preparing the seniority list, has placed respondent number 5 senior to the petitioner. Considering that respondent number 5 has been continuing his service since 2014, aggrieved with the said position in the seniority list, the petitioner has filed this instant petition, claiming that the respondent number 5 was inducted in the year 2019 as a fresh appointment. His appointment being set aside by the learned single judge. The respondent number 5 could not have been senior to the petitioner. I could have disposed it of me. Okay.
Lordship, I've already had, kindly keep it part heard.
I'm not watching. Let's however, during the hearing of the instant petition, the learned counsels for both the parties had prayed that the entire matter may be disposed of on a later date. The prayer is allowed. List this matter again on 29th of April, Wednesday, no, Tuesday, 28th of April.
Obliged.
This what continues the biggest issue. Otherwise, what he is saying seems to be right. His service is terminated.
They should have gone up into a higher forum. That's all I'm saying. As on did the orders.
They should not have not accepted fresh appointment.
He's not challenging her appointment, it's seniority.
Yes. He should not have accepted the fresh appointment. He accepted it. And on the basis of that appointment order, under the order of the governor, he's continuing now. That is the.
What can be done? Bring some judgments on off. So that I can get it handled.
Obliged.
Yes, Mr. Gidas, why are you here? What's the matter?
On this matter, I think, yes, my lord, this matter, a copy has been handed over to us by my client. It's a, he has retired, superannuated.
Wow.
But the case was about that I now in the first round of litigation, I came to the court because my case, DPC has not considered to the post of superintendent engineer, PWD. I came to the court said, no, his case should be considered. So according direction was given. His case should be considered with retrospective effect. And his seniority is placed above the junior. This was done, but now the next post is additional chief engineer. Now, by the time additional chief engineer, who was above me, the one Pradeep Sharma, he was for 3 days. And after ultimately he retired from the service. So next is, yes. Now the next due in the seniority list, final seniority superintendent, my name appears. But they did not consider it. They did not consider it by the time I superannuated. But even my case I considered. Today what I'll get? Today only monetary benefit I'll get if the court consider. What I have seen, notional, whatever benefit, it's not that my service, it is only that benefit I'll get. Now I received one letter, my lord, what it appears in 2024, even after superannuating. Kindly see this letter. Let me copy this. Please see the letter. I think it is given to the court.
And can this matter be taken?
No, it cannot be taken. That's why
Just see, they have to take instruction, that's why I am saying. See, first, second, third line, in the light of repetition. See, so and so the matter may kindly be clarified whether the incumbent is promoted retrospectively with effect from 22/11/2021, and if so, rule FR 17(1) of FRSR may be relaxed with request for release of his pay and allowances with effect. More so, as supernumerary post with effect on so and so may kindly be created to accommodate in the promotion with retrospective effect. So this is what is, this is of 6/5/2024, after being superannuated. So whether now they will take instruction, this was addressed to the commissioners, this is secretary. Public was.
Question is whether he will be promoted in a supernumerary post,
Yes,
a relaxing FRSR
yes, correct.
by not paying,
Yes,
or whether he will be paid.
yes.
This notion.
That's
has
the
been-
issue, my lord. And what I have done, I said by this will not do, we have taken step to file an additional affidavit by bringing this letter before the court. Because this has been addressed to us, kindly see down below,
Yes, yes.
it has been addressed.
Forwarded to.
So let this matter, let them take instruction in the meantime. We will help out.
Are you aware of this?
I appeal for the AG, my lord. We have nothing to do in this matter.
No, you have nothing, PWD has to.
It's the parent department of the.
PWD has to do.
Who has
PWD.
PWD and probably the count.
What I will do,
Nothing
my.
for PWD. Are you aware of the notification of this order, this letter?
This is probably issued by the office of the accountant.
Yes, accounts officer.
Accounts officer.
What I'll do, best way is to file the additional affidavit, serve a copy to them, let them take instruction on that. That will be more better. It will be on record.
Heard Mr. D. Das, learned senior counsel, assisted by Mr.
Yes, that's.
S. Das, learned counsel for the petitioner, and Ms. A. Bhattakur, learned counsel for the PWD, and Mr. B. Sharma for
Respond number 8, office of the accountant.
officer, respond number B. And Mr. T.C. Chutia, learned government advocate, corresponding number 1. Yes, corresponding number 6. Item number.
There are two matters, item 11, each have a pass on 11.
By this application, the petitioner has raised the, by this application, the petitioner has raised the violation, has raised the arbitrary action of the respondents for not considering and recommending the petitioner's name for promotion to the post of additional chief engineer, PWD. The petitioner also states that without that before the also states that petitioner in the meantime had superannuated superannuated on where?
30/11/2023.
Superannuated on 30/11/2023. As such, the learned counsel for the petitioner submits that either the petitioner could be, at this point of time, be promoted to a supernumerary post by creating a supernumerary post, or by giving him the financial benefits. The learned counsel has placed an instruction issued by the assistant account officer to the commissioner and special secretary to the government of Assam, Public Work Department, by endorsing a copy to the petitioner. Asking for a clarification as to whether the incumbent can be promoted retrospectively by relaxing the FR 17 within bracket 1 or his financial benefits may be released. In view of the said instruction, Ms. Learned Senior Counsel submits that he would like to file an additional affidavit, bringing in record the said communication and serve a copy upon the Learned Counsel for the PWD, which would thereafter get the proper instruction. Prayer is allowed. Okay, list this matter on 30th of April. 30th of April. 2026. Okay.
I pray for adjournment.
Why adjournment? Matter, my lord, very serious
Yes,
issue.
for morning, said you will file.
Yes, yes, that is on record, man.
They filed today,
Now, my lord,
Let them go through.
no, question is, my lord, they deny
Hmm.
that this petitioner got married without any finding, any finalization. And therefore, that reply made that she has yet not married. Only simple issue. That is
No, let them go through your affidavit.
not necessary. Only one point that she is not married. And Lordship kindly have a look this order.
Give them an opportunity, Mr. Mia.
No, Lordship, that is right, my lord.
Hmm.
But as per order dated 9/2/2026, there was a direction and both
No, what
parties.
is this matter about? You are only saying married.
No, question is, my lord, the petitioner unmarried daughter and she is entitled to get the pensionary benefit. And entire pensionary benefit obtained by the stepmother. That is the issue. And therefore, she is
She
also.
did not get.
Yes,
She's an unmarried daughter.
unmarried daughter.
Now they are claiming she's married.
Yes, now the department also passed a order, my lord. As per direction of this honorable court. Kindly have a look this order. Order is already also on
Go
record.
for
And for private responding.
Respondent, this stepmother.
stepmother.
Yes, she is obtaining all the pensionary benefit. This is the issue. And now, my lord, the order passed by the department. Yes,
Stepmother is not required to get. Otherwise, he is the wife of the.
yes, she is also entitled to get. But the claim is 50% is to be given to the daughter of the unmarried daughter because she is living separately. She is living with her first wife of the deceased employee, and first wife already been divorced.
So second wife is entitled for pension.
But first wife already been divorced.
Oh,
After divorce, the deceased employee got second marriage, and second marriage is entitled to get the pension, but the petitioner claimed 50%. And now, my lord, kindly have a look this order. This order, according to this order, maternity disposal. This order already on record. On last occasion, this order was on 23/2026. That order on record.
23.
Yes, 23/2026. And we have also obtained this order. Here, may I read this order? Relevant portion. The department also ready to dispose of. Only this, because matter is subsidized before.
What 7/3/2026 order?
7/3/2006 order. This is 9/2/2026.
No. 7/3 is the order by Inspector General of Police.
Yes. Yes, it is. May I read? Here, relevant portion, after hearing of both parties, this for consideration and dispose of the follows.
Where is 7/3 order?
7/3 order already has provided by the registry as per order dated 23/2026. We have already received this order through the registry. And that is also on record.
No, I'm not finding that. So what has to be done? You need.
Now, this order, Your Honor.
Yes, Mr. Bhuya, you're forcing for disposal, he's forcing for time. Where do I go?
No, already finding appear on this. Only this court order is required.
Show me 7/3/2000.
Yes.
It's not in the file, although it was supposed to be here.
But that also furnished before this court.
No, 73 order is not here. You please
Yes,
check and tell me.
yes, this order. 7th order. As per order dated 9/2/2026, both party was present before the
Wait, I'll read this,
Yes.
IGP's.
and next last paragraph. In view of the above facts, examination of records, and in compliance with the order of the Honorable Gauhati High Court, the claim of Srimati Parishmita Pathak, the petitioner, unmarried daughter of late Kanak Pathak, is considered and disposed of as follows. The department also already disposed of. 2, the eligibility of the claimant for family pension is acknowledged, subject to verification of the dependency and marital status as per rules. Number 2, the pension sanctioning authority shall process the case in accordance with the Assam Service Pension Rule 1969 and other relevant Assam GOT instructions.
So everything is left to the pension department.
Yes. So on this factual finding, matter is disposed of. They will dispose.
Next day, next day after.
They already decided.
Next day.
Only they are waiting the order.
Say that 50% take it from her and give it to her. No, I will give it to the pension department. They will
Yes.
examine. And if they find that the daughter's claim is eligible,
Then
they
will consider.
legitimate, then it will be given.
yes,
It will not go against you. You are white, you will definitely get the pension.
she's getting already.
Somebody else is appearing.
Yes, your Lordship, my senior will appear.
No, yeah, otherwise he will be bashed. It's okay. On the next stage.
After being, you'll say anything.
Then I'm being unmarried daughter. I'm suffering since filing of this case, and she's getting the all benefit and taking time. So short date may be given if any other day.
Heard Mr. Cave Mia, learning council. And Mr.
S. Hussain.
S. Mushahari.
S. D. Hussain.
S. D. Musha. For respondent number
6.
6. And you? For respondent number 2. Mr. The learning council for the private respondents. 6. Accommodation in the matter. And praised that the matter will be fixed upon
On 6th of April.
on 6th of April, next week. Will you?
6th of
After being.
Because already the finding arrived. Only the court order is necessary.
After being.
They will decide. Department will decide.
See, this is an unmarried
Yeah.
girl, she's not getting the
See,
money.
I am suffering. I'm suffering.
Senior will out of station also.
Maybe
And what about the arrears amount? She was getting the entire amount.
entire amount.
So the pension department will divide or they will what?
They will decide. Everything will decide according to law.
So not after the, before the, 600, say, choose on a date.
6 or
7th of April.
7th of
Okay, 7th.
Oblast.
Right.
Oblast.
List accordingly.
Firstly, and on behalf of my senior colleague, Mr. Eswali, kindly tell me for some.
After some time.
Yes. Thank you.
Yes, Mr. Decker.
Yes, Lordship. Before taking the merit of the case, I'd like to show you, Lordship, what is my prayer in this case, Milon. Yes.
What about the other? One is dead.
My page 13. Only one single prayer I'm file instant writ petition, Milot. Namely the direction. The directing the respondents, more particularly respondent 1, that is the Commissioner and Secretary of Government of Assam, Department of Housing and Urban so to dispose of my appeal, it is ought to be under Rule 18 of the Payment of Gratuity Act pending before the Commissioner and Secretary Government of Assam. So, my lord, I preferred an appeal before the Commissioner and Secretary, my lord, and which is
It has not been disposed of.
2024, my lord. Now, lordship, kindly have a look on the last order, 13 September 2024. Thereafter listed today, my lord. My lord, in that case, my lord, it's last line it is recorded. That's enabling to obtain instruction and file affidavit. Now 2020, I'm retired person. I retired 2028, my lord. So they have paid me 7 lakhs as a gratuity. After before my retirement, there's an amendment, my lord. I'm entitled 20 lakhs of gratuity, my lord. But they paid me only 7 lakhs. Then I preferred an application under Rule 7 before the concerned authority. They have not considered rejected my claim. Then under rule of this concerned act, my lord, I preferred appeal. Same has not been heard yet. Then I reminded to the respondent authority on representation also will find very last page, page 64. You kindly have a look, my lord. This is my last application for reminding the
What happened to the appeal?
nothing, my lord, not yet heard. So my humble request, my prayer, my lord, kindly, my lord, within 30 days, let them to consider my disposal appeal. Whether I'm entitled or not, a different question, but my appeal has to be disposed of, my lord. So time bound reaction may be given, my lord. That is prayer. I
When
wait.
did you give your representation to whom?
My lord, that respond number 1.
Commissioner Secretary?
Yes, my lord. Department of Housing and Urban Affairs. So my learned friends agree, my lord. Some time and direction may be given to dispose of the appeal.
So we direct the commission secretary to dispose of that within the time frame.
Yes, my lord.
That
That
is
much.
page number 29 also.
Yes, my lord.
Okay.
Instead of going to the marriage, my lord, I'm only praying to dispose of my appeal within a time bound.
It's
So you were paid with some gratuity, not the entire amount.
7 lakhs they have paid to me.
20 lakhs you are entitled.
Yes, my lord. As per the amendment. Again, my lord, that act has amendment extra before 2 days prior to my retirement, my lord. So I'm entitled to benefit. Even my grievance has been squarely covered, my lord. Once the citation I'm relying here.
Go into the marriage.
Yes. I'm entitled as part of the honorable court's decision, my lord. So, other similar person, my lord,
And
having
what
the,
order you challenged 3012?
yes, my lord, 1312, page 23. Annexure 6.
The Commissioner Secretary will go into.
Yes, my lord. And before the controlling authority, I made an application, my lord. It was rejected on 30th December 23. Then, my lord, against that order, I preferred appeal. My appeal at page 29.
Okay, fine. I'll direct the.
Yes.
I heard Mr. P.K. Decker, learned counsel for the petitioner, and Ms. S. Gora, learned counsel for respondent number 1. Respondent number 1. By this application, the petitioner has prayed for a direction to the Commissioner and Secretary, to the Government of Assam, Department of Housing and Urban Affairs, to dispose the appeal filed by the petitioner under section 8.
Under rule, my lord.
Huh?
Under rule 818.
Under rule.
Yes.
Rule 18 of
18?
the payment. What rule 18?
My lord, it is not, in advertently section 18 under rule.
So it will be rule again.
Yes.
No, see, you have written Act of
No,
1970.
no, under rule, automatic rule, my lord. Gratuity, yes. Rule.
Rule 18 of payment of gratuity rule.
Exactly, my lord. Yes, rule.
1972.
Yes.
1972. Pending, pending before the said authority. Full stop. The case of the petitioner is that he is entitled to the gratuity amount you read? The case of the petitioner is that he has last drawn his salary to the tune of rupees 1,07,074. And upon superannuation from his service, after 34 years of dedicated service, on 31/3/2018, the petitioner is entitled to the payment of gratuity under section 4 of the Payment of Gratuity Act. Here also you are writing Act in paragraph 3. And there is rule also.
Rule repair.
Payment of Gratuity Act 1972. Amended with effect from 29/3/2018.
Yes, my lord.
Which comes to around rupees 20 lakhs. Full stop. The petitioner submits that the respondent authorities, however, had released only 7 lakhs, only rupees 7 lakhs as gratuity.
Yes, my lord.
for non-payment of the remaining amount of the gratuity. The petitioner has filed, before that you have filed application, right?
Yes, my lord. That application lordship will find at my lord, page 20. And I shall find.
The petitioner had filed an application before the Assistant Labour Commissioner,
Yes, my lord.
Assistant Labour Commissioner Authority,
Under Rule 7, my lord.
under Rule 7
Yes.
of the said rules,
Yes.
and the same was rejected.
Yes. Page
What now?
23. Page 23.
And the same was rejected on the ground.
Lordship will find the ground at page, my lord. Page 27.
On the ground that
Page 27, very first paragraph. Then I'm entitled, covered by ROP 2010. That is their ground, my lord.
on the ground that the payment of gratuity under the Act of 1972 will be given to an employee who holds a post under the central government or a state government. However, in the instant case, it was held that the employee, that the petitioner is covered by ROP 2010. Which had a ceiling of rupees 7 lakhs. And as such, 7 lakhs was paid, and that the petitioner was not entitled for the remaining amount. Yes, claimed, right?
Yes. Yes.
Thereafter, what did you do? You filed an
Appeal. Page 29.
agreed with the said findings and conclusions. The petitioner filed an appeal before the appellate authority for the payment of the remaining amount of the gratuity.
My lord.
Before the
Commissioner and Secretary.
the appellate authority. Oh, full stop. Oh. The commissioner and they have not disposed yet.
Yes, my lord. Then, therefore, I made the representation thereafter.
However, the said commissioner and secretary, however, the said appellate authority, that is the commissioner and secretary to the government of Assam, Department of Housing and Urban Affairs, has not disposed of the appeal, although many years have gone by.
Yes, my lord.
Due to the delay, the petitioner again submitted a representation
At page 64. 14/6/24.
on 14/6/2024. For disposal of the appeal, for disposal of the said appeal. The representation was not considered, and as such, the petitioner has filed the instant application before this court. On examination of the case 10, this court therefore finds it fit to direct the appellate authority that is Commissioner and Secretary to the Government of Assam,
Respondent one.
Department of Housing and Urban Affairs, that is respondent number 1, to dispose of the appeal pending before the same within a period of 2 months from the date of 2 months will be more.
Well, I retired from serving in the 2018, my lord. So 1 month, 30 days. Yes.
Within a period of 1 month from the date of this order, from the
From
date
receipt of the certificate.
receipt of the present order. Petition is disclosed.
Yes, deep localized.
Is directed positively to disposal.
Deep localized.
directed positively to dispose of the present petition within a period of 1 month.
My lord, here, the petitioner is presently serving as a office superintendent in the General Reserve Engineering Force in Gauhati.
Matter can be taken up today?
Enjoying stay order is transfer matter since 24 Lord. He has been in Guwahati for since
Transfer matter.
My lord, my lord.
since 2021.
Here, the petitioner has been placed under law medical category, prominent,
Raised under what?
law medical category,
LMC.
LMC, law
No
medical.
medical category.
Category.
Yes, yes, yes. Since 2012, my lord. Here, the relevant rules is that those people, those personnel who are suffering by who are placed under law medical category, they are to be processed in a place, in a location where there is facility for the disability. For the,
The petitioner is a disabled person.
he is suffering from a
Hypertension and diabetes and obesity and cervical.
cervical spondylosis.
Those are common actually.
No. Because of all this, because of all this medical ground, he was placed under law medical category. Or if it's not a severe ground, that the department would not place him under the law medical category. Since it is a severe medical condition, therefore, on that particular disease, on the particular disability, he was placed under law medical category. So this is not, I declare myself as a law medical category, but it was declared by the department itself, by the department hospital itself, that I'm a law medical category, which has been placed for like temporary, and now it's met a permanent law medical category. And for which
Place, at what place? At
Now
what?
he's at Guwahati.
he is in Gauhati. He is in Gauhati. He is transferred from Shimla. He was transferred from Shimla to Gauhati in the year 2021 and posted here in Gauhati. Your Lordship, may kindly have page.
You are challenging that transfer order?
Yes, my lord.
Think
Yes.
that's one?
Yes.
No,
No. I'm from
Yongkyong.
kindly have, my lord, page 44, Annex 4. That is the impugned transfer order. Page 44. Annex 4. This is the, your lordship will find my name.
These are great employees. Yesterday, I think I had seen this.
Yes.
He
Your lordship,
mostly engaged in border areas only.
yes.
Oh, acha.
Your lordship, your lordship will find my name
Huh?
on page 45, my lord.
Okay.
Serial number 8.
Nawal
Nawal
Kishore
Kishore Kaushik.
Kaushik.
I was transferred from Gauhati to Yeongyong, which is in Arunachal Pradesh.
No, but then I see here Dibrugarh.
No, my lord. Here, see, the form to post in the first page, my lord. If you see the page 44,
Yes.
posted form to posted. There is a column. Yes.
From
Form to, yes. Form is from Gauhati RLC. This is regional legal cell. Each sector is in Gauhati. EC.
Acha, no, wait. You are Nawal Kishore Kaushik, right?
Yes, my lord.
Acha. And then he was transferred from
From
RLC East. What?
RLC means regional legal cell, which is in eastern sector. ES means eastern sector, which is in Gauhati.
Acha.
And I'm transferred to 761 BRTF, which is in Yeongyong, which is in Arunachal Pradesh.
BRTF means?
This is a border.
Oh.
Yes,
And it is places where?
it's in Yeongyong. It's in Arunachal Pradesh, my lord.
This is not mentioned here.
Yes, but still it's from the place, because if you search on.
Acha, it is in short form.
Yes.
Where do I find this?
Um.
Brahman
Brahman is the headquarters.
Yeah.
and Dibrugarh.
No. It's a regional office. It's an NRS regional
Nearest.
nearest.
Acha.
But I posted to the particular
This
Yeongyong.
is actually what? NRS. NRS means? Nearest?
Nearest regional station, I think.
Yes, regional station, something like that.
But the fact is, you were transferred from Guwahati to Arunachal.
Yes, Yeongyong, the particular place, Yeongyong, yes, not the interior part of the state, Arunachal Pradesh. Therefore, thereafter, I follow representation. Your lordship will find on page 47.
47.
Yes, my lord. My request was to diversion of posting on medical ground. I am not agree being transferring to any place. I'm just praying for a place where I could transport it and where I get medical facility. That's only my prayer.
Otherwise, this place at Arunachal is a high altitude area.
Yes, my lord. Yes, my lord.
HAA.
Yes, my lord. Here Your Lordship will find my representation. Here, just the relevant portion I'm reading. The para number 3, my lord. That sir, I suffering from the following disease: diabetes mellitus type 2, hypertension and obesity, cervical spondylosis, and lumbar spondylosis with degenerative disease. This is the description. That sir, I have placed in GREF 2 permanent due to above disease, and as per coating C2, I am unfit for HAA, ECC, and Hilidarian. At present, I am severely suffering from pain in back, neck, and left shoulder, and numbness due to cervical spondylosis and lumbar spondylosis. And I am in need of regular treatment for above disease. I need regular medical treatment of neurosurgeon and orthopedic surgeon. Presently, I am undergoing treatment at Narayana Super Specialty Hospital, Gauhati. Necessary medical documents along with opinion of neurosurgeon and medical board proceedings are enclosed for perusal and needful action, please. Pair 5 is, since neurosurgeon and ortho surgeons are not available at headquarters 76 BRDF and traveling in Hilidarian all the way to Dibrugarh for neuro and ortho, which is very far from unit location, involving long road journey, thereby further which may deteriorate my disability due to degenerative disease. Point 6 is, in view of the above, it is humbly requested that my posting may please be diverted to any other unit place where super specialty hospital with neuro and ortho is available, along with CGHS facilities, so that I can
What
get.
happened to his representation?
Yes, my lord. Here, my representation was rejected on page. The ship will find on page 49.
49.
Yes, my lord.
Annexure 6.
Yes, my lord. Yes. The third para. On the last from the last 2 line, my lord. Individual postings stands good. You are required.
Specialists are available at District Hospital, Yungkam, 3 kilometers.
Yes, I'm coming to it, my lord. I'm rejected, and I was rejected my representation, and thereby directed me to transfer to the Yunkyung. I filed an RDA, my lordship, will find on page 50.
For availability of doctors.
Yes, my lord. Here from the district medical officer, Upper Siang District, Yunkyung. From the particular hospital, I have filed an RDA, and this is the reply. Yes,
Those are not there.
yes. And then you should neurosurgeon Neil, orthopedic Neil, and then CGHC facility Neil, and nearest facility to Yunkyung with availability of both neurosurgeons and orthopedic surgeons.
Okay.
Yeah, this is all are near, my lord.
Then again, you made
Thereafter, after getting this RDA reply, I filed a representation praying that this is the condition of the particular Yunkyung medical hospital, and there I am suffering with this diseases, and I have been placed on a low medical category since 2012, and I need a regular treatment, regular checkup.
where is that law medical category? I have been placed at GRF 2.
Yes,
GRF 2 is what?
It's I'm coming back to that. I'm just first of all just pointing out the facts of the case. Thereafter,
Then you find another.
yes, I have, this is my third representation again. They have page number 54, my lord, Annexure 9. There, they haven't accepted my representation.
On what ground?
Later, teachers they just asked me. I was directed to transfer to the particular place without considering my representation.
Okay.
The thing is,
yes.
the teachers are no, it's not different. And then for being aggrieved by this particular Annexure 9, by this order, the petitioner is here by filing this particular this present petition, and it was this Annexure 9 was passed on 26 September 2024. Thereafter, the petitioner appeared. Approached this honorable court by filing this present petition, and the honorable court was pleased to grant interim on status quo on 4th October 2024. Thereafter, when the matter was remained status quo, your lordship will find another transfer order was passed in my name, where your lordship will find in the affidavit filed by the respondent, page number 17, running letter 17, my lord.
Yes.
Yes, yes. Here again, my transfer was diverted to 23 BRDF, which is located at Dabariju. It is also Arunachal Pradesh. I was transferred there.
So
During the
not
pendency of the
they
sweep.
have changed the place.
Yeah, they have changed my place.
Because this court gave us liberty to write order dated lordship, 4/10/24 to shift him somewhere else.
Yes.
So the Badijo is a district headquarters. There is a district hospital.
Yes.
Those are common lordship.
Yes, I'm coming back. I'm coming back to it, my lord. On this, the pendency of the writ petition, this was passed and like accordingly it was annexed by the department in the affidavit. There, your lordship may in reply, counter reply I have filed. Lordship may have my reply. Your lordship may have my reply. The running page is
73,
85, my lord. My reply, my next one. Yes. Your lordship, here I have put an application before this, before the district medical officer, the Dabariju. I don't know how to pronounce my name. And then this is my application through RDA, through email. And the reply from the district medical officer is on page 68, my lord, 86, my lord. On top, Mr. Files.
There is no neurosurgeon.
Yes, my lord.
orthopedic, no treatment facility. Okay.
Yes, that is the up to date regarding this newly posted place. Yes.
Same thing.
Yes. Coming back to my medical certificate, you lordship may kindly have page annex 1, page 17.
17.
Yeah, 17, my annex. Read petition, yes. She finds?
Yes.
Here, this is 2012. I have been placed under law medical category since 2012. Here, your lordship will find my 15 part 2. My diseases are written here. And then here, paragraph number 18.18, my lord.
Page 18.
No, point 18. Page 17.8, my lord. Lordship finds?
Yes, aggravated due to stress and
Strain of GRAF service.
no stress and what?
Strain, STRAIN strain. This is range. Yes. Of GRAF service. The disability which I am suffering right now, it is not my inborn or maybe inherited disease. The disability which I am suffering right now is aggravated by the service. I want to bring you to the point. And you will find on the next page, page 18, point number 2, a handwriting, my lord. You are placed in law medical category. LMC means law medical category. P2 means P means physical. 2 means like there is a code. 1, 2, 3, 4, like there's a code. So B2 bracket is PMT. This is permanent. You are placed in law medical category P2 physical, P2 permanent with effect from 23rd July 2012. This is the report. I have been placed under law medical category since 2012, and this was placed.
And report.
Yes.
Next medical.
Yes. And continue. My treatment is continue since 10. Since in my and I have been under treatment under the thing ortho and neurosurgeon. Lordship, kindly come to page 20. I'm just pointing out the relevant portion only, Lordship. This is disability, page 20, my lord. This is a disability. The column is there. The chart is there, my lordship. I'm suffering from all the things, cervical spondylosis, diabetes, all this thing. This is a certificate issued by the respondent. This is not a private document. This is a documents issued by the respondent hospital. This is
Okay,
yes.
I understand your case. Your
Whether in a
disability.
the lordship will details on this.
No, I'm coming back to the no, Lordship. Your Lordship, I'm coming to the, yes, I'm coming back to the rules.
She's medically disabled, she has many ailments.
Lordship has stated in effect, there are 90% with low medical under the same division.
That team, they may
To
approach
whom we
the
should
court.
accommodate? They have to
That
accommodate
they
all
have
those
to approach the court accordingly. They have. I'm just appearing for the. I am single also standing here.
There are no such facilities, so.
Yes,
Lordship,
yes,
this
exactly.
District headquarters, Dapodio.
No.
But then her RTR reply shows that there are no such.
Lordship,
doctors.
there is Army hospital nearby. You have stated in paragraph.
No,
6.
Lordship, I'm coming back to
You can
that.
have a letter.
Kindly have Lordship, page 21. Page 21, which is this page 21 is as per the rules of this. I'm coming back to the rules of the letter. But before that, here, Your Lordship will find that like the diagnosis I had, Your Lordship, friends, and then the code. There is some coding they used in that department. So the code, and then employability restrictions, remarks, and justification. Your Lordship finds that there's a chart. In the code, I have been placed to C2A, a small letter AB. C coding is COP code C2AP01. These are the like depends on my disability. They make them marking. Accordingly, my restriction is unfit for high altitude area, extreme of goal place, and then to be under surveillance by
Where is that?
Yeah,
That you are not fit for high altitude area?
21, my lord, page 21.
21, yes.
The chart, Your Lordship. There is a top code and then employability restrictions, remarks and justification.
Employability
Yes.
restrictions,
This is the
For high
yes,
altitude area.
This according to my disability. They have a code, and then according to the code, they have divided the restriction that I should be aware of. This is the chart, and then this is as per the rules. And I'm coming back to the rules also, and then. You will find remarks in the remarks and justification below. Climate change in climate may worsen the disability. Monthly AMA review all the seniors finds, and 3 months specialized review. Strenuous exertions may worsen the disability. Days type, debilitate. All these things are as per the report. Coming back to the guidelines which regularize the Your Lordship will find page 22. That's the annex 2 is the guidelines which I have annexed. Here, Your Lordship, this is the revised guidelines for medical categorization, GREF personnel. On the right side, Your Lordship, medical category. Yes, I fall under column B, GREF category 2. Yeah. The various medical categories for GREF personnel are given below. These medical categories are to facilitate deployment of individual by the administrative authorities and also to help the individual to recover from their disease and disabilities. I have placed into this category, and now the department are denying me to a place where I should get proper treatment. They are transferring me to the interior. Fine, if there is, they may post me anywhere, but my prayer is that to get me posted to a place where I get medical facilities, because the disability which I am suffering going through is aggravated by the service. Therefore, I am praying for this only. And kindly have, my lord, I'm annexer 39. Annexer 3, page 39. This is the record office instruction, which is adopted to regulate the posting of GREF service. So she finds the chapter 24. Yes, the relevant portion. I'm taking Your Lordship to the relevant portion. Page 42. There, on the right side, on the left side, Your Lordship will find deployment and adjustment of low medical category personnel. On the point number 32, While issuing the posting orders of personnel of low medical category (LMC), the recommendation of medical authority available in the service documents are taken into consideration and personnel are posted to a place where the requisite medical facilities are available. This is the guidelines they are, and now they are not following these guidelines. Yeah, and Lordship, I am 57 years old now. I have only 3 years left to be retired. I have been serving throughout my year, year in the service. And my physical disability is
40 years is the retirement?
no, I'm 47 years.
47.
Yes, no, I mean yes. No, I'm 57 years old.
Or 60.
Yes, yes. 57 years old, 57 years old. I'll be retiring shortly. I wanted to be posted to a place where I get proper medical facilities. And I am placed in the low medical category, not by myself, but the department have put me in the low medical category. Why now? Why they're denying me medical? My only purpose is my only prayer is here is that to place me to a place, post me to a place where I get proper treatment as per the rules and regulations. It's up.
So, Mr. Chakraborty, what I'm thinking.
Just now check it out, Lordship, the Porigio is not considered as a high altitude vehicle.
She's
Some meters above the sea level. Lordship, can you check out in the AI?
No, but then her RTR shows that those doctors are not there. So you place him at a place where the doctors are available nearby.
Yes, stated in our affidavit, moreover, Dr. has been in Gauhati since 21, more than 4 years. Tenure posting is 3 years at soft posting.
Okay, you take it.
Because of the status quo, I was
Doctors and medical facilities are there. Not Doporizo or Yinking.
Lordship has stated in that the Porigio,
Why are not-
90% with low medical category, all those will come.
let them approach them accordingly.
And
Yes,
some are
yes.
waiting to come to Gauhati also. He cannot wait there for all the years, Lordship.
But then you're not
Out of
questioning
18
her.
years, he enjoyed 25 years in soft posting. That was stated. in
That's
our
not my
affidavit.
choice of posting. Though I have served in soft area, but that's not my choice of posting.
Then-
I was
then-
transferred to the
Then this
place.
should not be
Yes.
his choice of posting. Let him go there.
You are finished, let them finish.
Then he should go there. If those are not.
Take her to something because
Not even seeing the disease, Lordship. Those are common to lifestyle disease, Lordship.
Even so common, then why you have placed me in the low medical category?
actually no. Wait, take a sip. I'm just talking to you. No, what I feel is why
Lordship
have
knows
not-
first they have to go and join. Thereafter they can file it. But in this case, anyway, stay whatever first, Lordship.
Yes, of course, Supreme Court has said, go
Yes.
join and then.
Go
file.
and join. Then after he file a
But
representation.
then, because
And more than Lordship, according to our Lordship,
why some other places not there apart from Arunachal,
I have some
high altitude area.
but Taporijo is not, Lordship can check it out. Not consider higher.
But then you're not questioning her.
And there is army hospital nearby. He can avail there
the
also.
army hospital is in Dibrugarh, which is 270
Each and every,
270 kilometer away, and which is I have to take long journey hilly terrain.
No, not Dibrugarh. He said that army hospital is there near.
it's stated in our affidavit.
Yes, I have replied to that. I want to reply to that particular paragraph. That is 270 kilometer away from the particular station where I have been really posted here.
That is a fact, Mr. Chapo.
No, no.
70 kilometers, quite some distance.
Well, Lordship in test one of the Lordship will go all those details, Lordship, whether court can go into all those details. Questioning the
To
justice.
see whether he is properly posted or not.
Lordship, he has out of 29 years, 25 years in soft posting. He can't have the cake and eat it too also. Others are waiting to come to Gauhati. You have to accommodate them also after serving in the hard posting. It's only the original district headquarters, Lordship. Nowadays, all district headquarters have a specialized doctor, Lordship.
Where have you written? Your affidavit?
Lordship.
Doctors are available.
Paragraph 6,
Wait.
57.
Then what have you replied?
And paragraph 9, Lordship. It's stated that others are waiting for their turn, Lordship.
Lordship, in paragraph nine, Lordship, page 59, it was stated that within 3 kilometers, there is a specialist doctor, medical, army and civil hospital. Within 20 kilometers,
Within 3 kilometers.
there is specialist doctor, and within 20 kilometers, there is army and civil hospital. And at Daporiju, there is M1 medical facilities, both for army and medical civil.
My RDR reply is clear, Lordship. By just placing without any record comes and work.
And para 13, you have stated that there are 94 employees with LMC waiting for their turn.
And what
Paragraph
is your
14.
reply with regard to that 3 kilometer to 20 kilometer hospital?
Please bear with me. I have denied my lordship. Where there is no medical facilities, so how can I transfer there? I am accredited by my disability is accredited by the service. I'm 57 years old. I'm not aggrieved by the transfer order. I just wanted to be posted to a place where I get medical facilities. Lordship will find my medical documents in my reply as well, Lordship.
Let him go and find a fresh representation.
And again, they will transfer into another interior place where if there is no medical surgeon required medical doctor, then like I have to come back to the court. It's unfair.
You have not denied that there are no hospitals. You have just said that specialists are not there, right?
I need a specialist doctor, Lordship. Ortho and neuro.
Yes, specialist doctors are there in the hospital. Army hospital is
There is the waste hospital waste reference in Dibrugarh, which is 240 kilometers away from my station.
no, not 3 kilometers only, and 3 kilometers for specialist.
That they have to bring in record.
No, they have already said, and you have not denied that.
No, I have denied it, Lordship. I have denied it.
In a paragraph,
Which paragraph you are referring to?
paragraph 9, they have, and reply to the paragraph 9 is a paragraph 9 only in your reply. No specialist doctors for
Yes,
this
I need a
and
specialist doctor.
at Daporiju.
My RDR reply is clear, Lordship. I have referred to my in Kyung village and Daporiju, all those there no specialist doctor. I need a specialist doctor for my treatment, not a general doctor.
Okay, you do one thing and you write those disabilities that you suffer from, and then you go and join Daporiju and make an application.
And again, if they transfer me to a place where that there is no,
And make those observations that
I also have some list where there is medical document, medical. I'm 57 years old. Just
you can give your,
considering my age, yes.
you can
Then
give
you
your,
consider responsibility.
give your choice stations.
I have my lordship.
Oh, no, while making representations, you give your choice stations and they will consider. You have not given your choice stations in any of the representations, it seems.
No, I have no joint business. I wanted the department to put me to a place where is medical.
I see,
Yes.
yeah. But then they have seen army hospitals are there and they have accordingly posted you. So you make few choice stations and give the representation. You yourself find out where your specialist are, where good hospitals are there.
In the area nearby, facility nearby, there is no as such. Always like I could have went there because since my transfer has been diverted to the from the income to the laboratory. If there is a medical facility, I could have went there.
Okay, I'll make it.
He's office superintendent, he's not doing mental workload, never. mind.
Acha, are you
Whatever it
working
may
in
be, the
Guwahati?
place,
Superintendent.
the place
He's
where,
office superintendent.
the place where,
Acha, you are working in Guwahati now?
right,
Yes.
right, no, my lord, yes.
So let him work in Guwahati, give a representation from here. giving his choice stations and then you decide
Within a time bound, Lordship.
within a time bound.
Till then, I may be
Yes,
protected.
you'll be in Guwahati. Third miss, P. Wapangla, Learning Council for the petitioner, and Mr. T. Chakraborty. B. Biplab Chakraborty for responding for the respondents. For the respondents. By this application filed under Article 226 of the Constitution of India, the petitioner has challenged the transfer order dated 12/9/2024, by which, no, transfer order is where?
Page 44, my lord.
Page 44.
Yes, 10/8/2024.
10/8/2024. Transfer order dated 10/8/2024, by which the petitioner was transferred from Guwahati to Yingkong, Arunachal Pradesh.
761,
Ah.
761 BRTF
No, from
from RLC East Sector ES.
more Guwahati to Delhi, no. From RLC ES.
Yes.
RLC within bracket ES, Eastern Sector ES to 761 BRTF. That is from Guwahati to Yingkong. Arunachal Pradesh. Further, during the pendency of this instant writ petition, the petitioner was further transferred to a different place in view of the order. That is to Daporiju. Daporiju.
Page 70.
Page
70.
70. 170. From Delhi to Kikusa. From Daporiju, where is that Daporiju?
Page 7. It's just on the third line. No, it's not even there, but in 223 BRTF. It's
BRTF?
yes.
23 BRTF, that is Daporiju. DOPORIGO.
TABORIJO.
JO. Daporiju. The case of the petitioner is that he was placed under the he was placed in low medical category. P3. P2.
Permanent. PMT.
Within bracket P permanent.
Yeah.
Within bracket PMT. With effect from 23rd July 2012. And it is his case that he had ailments due to his service issues, due to
Stress and strain
due to the stress and strain
of GREM.
in his service. The petitioner further states that he is suffering from cervical spondylosis, diabetes type 2, obesity, and what else?
Primary hypertension.
Or primary hypertension. And it is also provided that the petitioner with the said ailments is unfit to work in high altitude area, having extreme cold conditions. It was also stated that if the petitioner is made to stay in such areas, then it will worsen his disability. The learned counsel for the petitioner has placed the revised guidelines for the medical categories of revised guidelines meant for the employees working under the grave under medical issues. But what have you placed? Which paragraph? Which page?
I refer to point 3, my lord, medical categories that I have placed under GREF category 2.
And that he is placed in GRF category 2. Also place something else. What?
Yes, yes, the next annexure 3. Relevant portion is
Page.
page 42. On the left side is.
Full stop. It is also provided in the set guidelines that while posting personnel of low medical category LMC, the recommendations of the medical authority has to be taken in consideration. And the personnel should be posted at a place where requisite medical facilities are available. The petitioner being agreed with his posting first at Yingkung, filed a representation for posting in such areas which provides for medical facilities so that he can avail the same. He filed the said representation on 13th of August 2024, stating inter alia that he needs regular treatment of neurosurgeon and orthopedic surgeon. And that the facilities are available at Dibrugarh, for which he has to travel many kilometers from the said said place of posting. So the said representation was, however, rejected on the ground that specialists are available at district hospital, Dinkyong.
But can you see one thing, Lordship? Page 20. He has been placed in low medical category for diabetics only. 23. Not for spondylitis and all.
No, she will find on the page 20 in the
Page
bottom.
serial number 23, page
19,
20.
Lordship, have
Page 20.
page 20, I'm referring page 20, 19.
20.
19.
Where?
Disabilities, my lord.
No, the abilities I've seen, but
Yes.
23, serial number 23. Instruction given to the individual by the president of medical. You have continued to be placed in low medical category showing so for diabetes mellitus type 2 only.
This is 2024 medical report. I have been placed under
Not
low
for
medical care
spondylitis and other.
2012, my lord. 2012, your lordship will find on page 17, my lord.
okay. Then what is rejected on the ground that specialists are available now in Yeongkong, which is 3 kilometers away from the place of posting. দুবার করুন place of posting. Right? আচ্ছা, from the place of posting. In response to the said rejection order, the petitioner filed an application under the RTI Act asking for information as to whether the specialists are available nearby. And the reply furnished to the petitioner showed that the same are not available. In view of the said reply, the petitioner again made a representation to the authority concerned on 18 September 2024. Which was again rejected by the authorities concerned, and direction was given to the petitioner to go and join the place of posting. What about the ID, Toporijo?
Yes, during the pendency,
Where is that RTI application?
yes, the receipt will find on my reply.
Further, as stated above, during the pendency of this writ petition, the petitioner was
Page 86.
petitioner was transferred to another place called Doporijo, to which the petitioner again made an application under the RTI for finding out as to specialists are available there or not. And a reply was given that there were no neurosurgeon or orthopedics at the district hospital of Doporijo. Daporijo. Daporijo. You again made a representation? No.
No.
As such, the petitioner submits that since it is given under the law that the petitioner should be posted at a place where the medical facilities are available nearby, he
You also may kindly have my medical documents, which I annexed on my reply.
he objected to the transfers made to either ICOM or Daporijo. To substantiate his medical issues, the petitioner has also annexed his medical certificates. And as such, he prays that he may be transferred to any other place where the facilities are available nearby. Mr. V. Chakraborty, learned counsel for the respondents, however, submits by relying upon the affidavit filed that hospitals are available that is Army Hospital with specialists therein at specialist dairy as well as civil hospitals at Daporijo.
One more thing, whether this orthopedic and neurosurgeon were necessary for, because point number 21, percentage of disability not available. Why should orthopedic and neurosurgeon be required?
I'm
Because
suffering with disease.
And the instruction is for diabetes only.
No, Lordship,
LMC has been placed in case of diabetes only.
No,
not
Lordship.
Spondylitis, Lordship.
no, I have been placed on the Lordship will find my medical documents in 2012.
He further submits that the hospitals are within 3 kilometers. No, the hospitals where specialists are present are within 3 kilometers. And the army and civil hospital are within 20 kilometers from the place of his posting. That is Lincoln. And near Daporiju also he submits that medical facilities, army and civil hospitals are available. He further submits that the petitioner was placed under low medical category only for his suffering from diabetes type 2 and not for other ailments. And he also submits that as far as his cervical spondylitis is concerned, the report says that the same is not severe. And as such, the specialists mentioned by the petitioner are not required in the present case. He further submits that the petitioner had worked in soft areas for many years. And like in other cases, he was transferred to other areas under the grave regulation, which is not illegal in the eyes of law. Well, it is the case of the petitioner that he suffers not from. Yes, Mr. Sharma, you are waiting for some matter.
Before, to leave also for outside. I do 34 minor, there is a, on the spooner 3, the notice has not been completed. It is written has been.
You need to be here. I'll record your presence and I'll
Yes, sir.
write that. I'll give that on.
Otherwise, my junior will go.
Yes, you can. That's what we do. He is not suffering only from diabetes type 2, but also from other ailments such as cervical spondylitis,
Degenerative disease,
degenerative diseases, as well as there was one more,
primary hypertension, obesity, primary hypertension.
primary hypertension, which is reflected in his medical documents. And it was also mentioned in the said documents that he needs to visit specialist after 15 days. After every 15 days,
Review follow-up, yes.
to be reviewed periodically. After 15 days, to be reviewed periodically. It is, full stop. It is also provided in the guidelines that persons of low medical category to which the petitioner has been put under should be posted at a place where requisite facilities are available. By making, full stop, by making appropriate applications under the Right to Information Act, the petitioner was apprised that in both the places, that is Rincon and Daparijo, the said facilities are not available. Although the same was not accepted to by the respondents, saying that medical facilities are available near the said places in the form of army hospitals as well as civil hospitals. Full stop. While rejecting the first representation, it is averred by the authorities that indeed that although petitioner mentioned that he needs orthopedic treatment, but as per medical board, he is suffering from diabetes type 2 and other diseases for which the treatment is available nearby. And while rejecting the second representation, no such reason was given by the authorities concerned. Full stop. Since it is required in case of the petitioner that he needs medical treatment, this court finds it fit to direct the authorities to consider the case of the petitioner by applying the guidelines meant for the GRF employees as well as the medical certificates issued by the petitioner. As such, this court directs the petitioner to file a fresh representation before the concerned authority within a period of 1 month, no, within a period of 2 weeks from the date of this order, from the date of the receipt of this order, which will be considered by the authorities concerned in the manner stated above within a further period of 2 weeks.
2 weeks from today, he will file
And then further period of 2 weeks thereafter. Full stop. Further, it is directed that the petitioner be allowed to work in Gauhati till his representation is disposed of in accordance with law. And by taking into consideration the health of the petition. Petition is disposed of.
Your Lordship, may kindly add like specific neuro and surgeon, neuro and auto surgeon specifically.
That's the.
If he's a
that
medical
medical
facility,
code
like
inside
medical
also
facilities and like
What did I say, Laura?
medical facilities only,
Medical
neuro and
facilities?
auto,
Including the availability of
neuro and auto.
required doctors, required specialists, including the availability of required specialists. Huh? जो pursue medical facility. Yes, 1 o'clock rest at 2.
But this would need some deliberation, I presume.
15, it took money. Yes,
In that case,
So maybe fix my after visit. Some replies have been filed. I want to go through the.
reply filed by him.
Yes.
Heard Mr. H. S. Manik, Learned Counsel for Petitioner, and Mr. I. Bhattapur, Learned Counsel for Forest Department. Mr. Bhattapur, seek some time for going through the reply filed by the Learned Counsel for the petitioner. Prayer is allowed. List this matter on, then after the list this matter on 28th of April.
for admission.
For admission.
Admission.
For admission.
Okay.
Every person.
Not matter relating to pensionary benefits. Those you can see the first order, my lord, 25-10-24, my lord. Just for amendment.
Pleadings are
Complete, my lord.
order dated
25-10-24, my lord.
25-10. This was order.
Yes, my lord. So, my lord, basically that was my grievance. Now, lordship may kindly see page 12.
So
Para
basically,
11.
your grievance is that the bank authorities have not released your amount,
Yes,
although the department has given,
absolutely.
and the calculation was also wrong.
Correct.
And then
Some
some excess
recovery, recovery has been made.
some recovery has been made.
That was basically my grievance. Now, lordship may kindly see page 12, para 11. Para 11, my lord.
Yes.
The first two line, my lord. Last salary drawn was 42,505.
Where, which lines?
Page 12, para 11, my lord.
Yes.
Second line, my lord.
Starting.
Yes, second line. 42,505 was the last basic drawn salary. Now, lordship, last paragraph, my lord. These are the amount which I have received, my lord. Leave encashment, my lord, DCRG, GBF, my lord. These are the amounts I have received. Now, lordship may kindly directly come to, my lord, the statement, page 54. My bank statement. So, my lord, this was the salary in, my lord, salary slip I have, my lord, and enclose, my lord, the bank statement. Page 54.
54.
In from below, my lord. 1, 2, 3, 4, 4. Serial number 4 from below, my lord. 1st December 2022. That will be, my lord, 42,505, my lord, correct?
This is by way of salary.
Yes.
Hmm.
So this bank statement I have enclosed. Now, Lordship, can you see the calculation part, my lord, my BPO, page 50, my lord.
Date of retirement was 30th of November.
Yes, my lord.
Oh.
30/11/22, my lord.
Oh.
So, my lord, I have served 32 years, 11 months.
Hmm.
Now, my lord, can you see my pension, monthly pension is fixed at 15,770. Lordship got it?
Hmm.
Now, Lordship may kindly turn next second page, my lord, 52.
Hmm.
52. Lordship may see in the column, my lord, column number 3, my lord, last total recoveries, 6,87,807. That was the total recoveries.
From you.
Yes, from the pensionary benefits, my lord. That was what I understood, my lord.
So that was overdrawn by the petitioner.
That was first, my lord. They have make a recovery, my lord.
Mixing of things, the recovery was 46,000.
46,813. This is other government dues.
Other government dues. Total recoveries.
Provisional DCRG is what?
Before the final DCRG sanction, my lord, he was sanctioned at an amount of rupees 6,40,994 as provisional DCRG. Now the
DCRG is what?
death come retirement gratuity.
Acha.
Now the actual he should have received is 7,07,282. So this has to be adjusted. The provisional payment that was made has to be adjusted against the final amount. Thereafter, whatever remains is paid.
So the provisional was 6,00,000.
Yes.
Now, Lordship, the subsequent development is my lord. Lordship, I have just, there is, my lord, in the record. I hope last time I have produced, my lord, that is part of record, my lord. Lordship may see the letter. That letter has been now, my lord, bank has returned back those documents. And they have addressed to the treasury. Now treasury has sent to the AG. And the AG again now sought, my lord, the documents, that incomplete documents, saying that documents are incomplete, so we could not proceed ahead. Kindly you furnish all the particulars. That was what the subsequent development, my lord, I have, Lordship.
AG has written it back to the treasury.
Treasury, saying that the documents which have been forwarded to our office is sometimes some documents are missing. So complete it and
Send it back.
hand it back so that we can carry it out ahead. Now, Lordship may see, so far the calculation part, my lord, there is a office memorandum, my lord, 12 July 2007. Lordship, that is part of record I have produced last occasion.
It's not in the affidavits.
Not in the affidavit. It's regarding the rule, amendment of rules, my lord.
I don't know, see,
Lordship, I can just.
or I'll give you back, you can.
Yes, Lordship, yes.
You can calculate. You can calculate.
Clause 4, my lord.
Yes.
After this, my lord, 50% should be the, my lord, amount, my lord. So if in the events, my lord, my salary is 42 above, my lord, then at least 20 some plus should be the calculation draft. That will be the draft, my lord.
Not required.
So, my lord, that is the rules. I'm just, my lord,
Okay, 50% of the last drawn salary.
yes, that should be the calculation, my lord. But they have taken it, my lord, my salary, my pension is fixed 15,000 something, my lord, as I have shown, my lord, annexed 1.
But it should be some 20 some thousand.
20 something plus. Ito na lang. Ito.
So,
So, my lord, apparently on the face of record, my lord, some calculation is,
That aspect also I've clarified before this honorable court of the last opinion. He is again raising that issue, my lord. His gross salary was 42,505 rupees.
Where?
The bank statement which is showing, my lord, it shows an amount of 42,505, I suppose.
Wait, I'm not.
Page,
page 52.
Page
of that bank statement.
Yes, page 50,
No.
54.
Statement.
54.
Page 54,
Ah,
the fourth class entry probably 42,505.
40,
He's claiming to be, he's claiming
42,505.
He's claiming that amount to be salary. Absolutely correct, my lord. It's the gross salary. But pension is determined on the basis of the basic salary, basic pay. His basic pay was fixed in the pay band at rupees 27,640, plus he was receiving a grade pay of 3,900. So the total comes to, my lord, 31,540.
Basic pay.
Basic pay.
How much? 31,000?
540.
Mm.
So 50% of that would be 15,000 something. The amounts which were added to that salary components were dearness allowance, hill allowance, HRMA. These are not added, taken into consideration while computing the pension. But this is the structure. I clarified all these aspects on two occasions. Again, he is raising these issues, my lord.
So,
This is the
2,000
calculation.
is rightly calculated according to him.
The calculation
No, no,
is there itself.
And the other issue that the bank has withheld the payment, what about that? Bank.
Yes. So what happened that petitioners have a bank account in our branch lordship. I am for the respondent number 10 and 11. What happened in particularly case, the PAPU and all the documents, other related documents, initially he was submitted. When he filed a case before that, Honorable Court is directed to place all those documents to our branch, my lord. Accordingly, he submitted, my lord. Then we forwarded to our branch. There is a branch, my lord. That is a, my lord, centralized pension processing center who look into that, my lord, pensions matters, all those things, my lord. Then, my lord, they are saying that, my lord, that original PPU was, my lord, was some problem is there, my lord. Then they saw the revaluation PPU is required, my lord. So as because, my lord, his pension is due from 2023, my lord. And as per that Assam Treasury Rules 1917, my lord, Rule 22, my lord, revalidation PPU is required. Accordingly, my lord, that Central Pension Processing Center has wrote a letter to the petitioners, my lord, to obtain that revalidation PPU. And revalidation PPU issued by the Treasury officers, my lord, after getting that final approval from AG, my lord. That after now, I do not know, my lord, after this copy, my lord, 27 till 25, my lord, that bank has written a letter to the petitioner. Now, our stand is, my lord, we are only a releasing authority. Sanctioning authority is, my lord, PHC and the Treasury, my lord. So, after obtaining that, my lord, we are ready.
We have already revalidated
Yes, sir.
on 12/2/2020.
You have sent a revalidated PO.
Received the proposal in the month of December 2025. It was done, revalidated. Our part.
Now, pardon.
Send it to the bank.
No, we will not send it to the bank. We will probably
We send to the Treasury officer, my lord.
Uh-huh.
Then Treasury officer will send to us, my lord. Now,
Not been done.
not done. As on today, we have not received that this one, my lord, revaluation PPU, my lord. From that
Let them
Treasury.
take instruction then, what happened?
No, Treasury officer can say, man.
let them matter be disposed, my lord. At least we.
After this,
For the treasury.
sir, after receipt of that, we immediately, my lord, we have no wish to release that money. Can we dispose of within a time, to direct to the Treasury officer, as because my lord, AG already give that approval, then my lord.
AG has given the
Yes, sir.
approval.
We had sanctioned it long back, but they required a revalidation. We have revalidated it on 12/2/2022.
2026. Okay. That will do.
No.
I will tell the treasury officer to give the proper instruction to the bank. What? Release.
Release
It has been approved by the AG. And revalidating was sent by you, that is the PWD. No, that VHE.
AG, Office of the Accountant. It was, the proposal was sent to us in the month of December 2025.
Who had sent the proposal?
Treasury, my lord.
For revalidating. Sent by the bank. And then AG has cleared. And it has been sent to the treasury. Treasury has not
Sent
given.
to the bank.
Bank, that has not been done.
We have not received.
Direct treasury to send it to the bank, and accordingly bank will release. But as far as your calculation is concerned, this is scientifically correct. 15,770.
Lordship may kindly, for my satisfaction, Lordship.
These are judgments.
Yes. It is settled, though, my lord. Lordship is aware.
What? 50% of the last drawn salary.
That is as per rules, my lord. Now, so far the deduction part is concerned, my lord, Raffi judgment is there, para 18. It's very, I have indicated the paragraph, my lord. Except, my lord, grade 4, I'm a grade 4 admittedly. So that cannot be, my lord, deduct. And after retirement, before retirement, in 1 year, my lord. So,
I have to tell
that
you
cannot
the
be
deduction is
also deduct.
Document is page number
Page number
51.
51.
no, not 51.
52. 52.
She may kindly take up the first column. There is an amount mentioned, my lord, 7,07,282 DCRG. This is the actual receivable by him, my lord. Now, there is another column which says provisional DCRG. That amount is 6,40,994. She has got that, my lord. So he has received a provisional gratuity of rupees 6,40,994, my lord. And there was a recovery due to overpayment, my lord. That amount is 46,813, I suppose. If lordship adds up these two amounts,
Then it will come to 6,87,000.
the calculation is right. Well, lordship will just, it comes to 5,87,807.
How come you have deducted or what? From the provisional one, you have deducted
He has already received this much.
provisional.
Provisional plus recovery. If you add these two amounts, that would come to 7 lakhs and something, that amount.
No,
Remaining.
like 6,87,000, I think. No.
6 lakhs.
So that provisional thing has to be recovered from him.
No. That has already been paid. That has to be adjusted against the final DCRG amount.
DCRG.
So
And then
that
DCRG is 7,07,000.
7,000 plus 40. This
46,000.
document is not at all legible. 46,000.
6,813.
813. This amount has to be deducted from 7 lakhs. 7,000.
282.
282. So amount receivable by means 475. There is no deduction, my lord. What has been deducted is 46,813. That is due to overpayment. And we are just the implementing authority of the government, my lord. Whatever instruction is given to the Office of the Accountant General, we just implemented that instruction and direction. That direction and the instruction has come from the parent department of the petitioner to deduct this amount of rupees 46,000 because there was an overdrawing. So apart from this 46,000, nothing has been recovered.
Okay, heard Mr. N.K. Muri.
Yes, ma'am.
Learned counsel for the petitioner, and Mr. P. Sharma, learned counsel for
Accountant General.
Accountant General, and Mr.
K. Das.
A. Das.
K. Das.
K. Das. Learned counsel for
10 and 11.
10 and 11. The petitioner has filed his application under 226 of the Article 226 of the Constitution of India. Mainly with 3 points. 1, the petitioner who was working as grade 4 employee in the Office of Assistant Executive Engineer, PHE Department, Chowki Hola, Subdivision in Karbi Anglong District, Assam, had retired from service on attaining the age of superannuation with effect from 30/11/2023. 23,
22.
22,
Yes.
22.
Yes, madam. Para 3.
Yes, 30/11/9 to 2022.
Yes, madam.
Thereafter, the petitioner submits that although the authorities had sanctioned the payment for pension by issuing the PPO, the bank authorities had not released the amount to the petitioner. Which has caused serious prejudice to her. The petitioner also submits that her pension has not been calculated as per the rules. And she has also assailed the action of the respondent authorities in withdrawing the excess withdrawal, the alleged excess withdrawal of money from her pension. As far as the first grievance is concerned, that the bank authorities have not released the pensionary amount to the petitioner. It is stated by the learned counsel appearing for the bank authorities that the officials in the bank, after verification of the documents of the petitioner, had Mr. Sharma, why did the bank had sent back the for what re-verification? Revalidating, right?
Yes,
After verification of petitioner had sent it for revalidation
of the PPO member.
of the PPO. PPO?
PPO, pension payment board. Pension payment board.
Yes, of PPO. Yes, give it to me. PPO to the AG, to the Office of the Accountant General.
The bank could be sending it to the treasury officer for.
Oh, yes. I would send it to the Treasury Officer, not to the Accountant General. To the Treasury Officer.
No, that.
Who in turn?
That letters was directly sent to the petitioner, my lord, from the CPP, my lord, Centralized Pension Processing Center, to get.
So no, the bank authorities have directly sent it to petitioner.
Yes, my lord. So then, my lord, petitioner has to obtain that revalidation people from the treasury. And treasury, my lord, is not a alone my lord, authority to issue the revalidation PPO. They has to take approval from the AG. Accordingly, that's then my lord said that AG has, yes.
Okay, then you write, don't write to the Treasury Office. Revalidating, what did I say? Just read it again. To the petitioner, who got the revalidation done by the Treasury Office.
Letter has been addressed to the treasury with a copy to us, madam. As per the record, madam.
For revalidation to the Treasury Office with a copy to the petitioner. To the Treasury Office with a copy to the petitioner. Who got the revalidation of the PPO done by the Treasury Office, who in turn got the approval from the Accountant General Office. Further, it is stated by the learned counsel appearing for the AG that the revalidating document or what?
It was revalidated.
PPO. Revalidated PPO was sent to the Treasury Office. However, the learned counsel appearing for the bank authorities submits that they have not received the said revalidated PPO from the Treasury Office
Either treasury office or applicant. Applicant can also minor.
or from the applicant, who can also send the same. So the fact remains that the bank authorities are not intentionally withholding the payment of pension to the petitioner, as alleged by the petitioner. Full stop. Since it is approved by the AG and it was sent to the Treasury Office as submitted by the learned counsel, there is no impediment for the Treasury Office or the applicant to send it to the bank authorities, who will finally disburse the pensionary amount to the petitioner. The second point raised by the this is from the State Bank of India. That
Yes,
is
madam, that's that. That's a, this the unit we discussed that my pensionary benefits.
the second grievance raised by the petitioner, that calculation of the pensionary amount is not correctly done. This court holds the following. The petitioner submitted that as per rules, the pension amount should be 50% of the last drawn salary. And he submits that since the last drawn salary is rupees 42,505, the pension amount would come to 20 plus, right? Take out 50% of 42.
Yes, madam.
Would come to more than 20,000 as salary, as pension amount. He has placed, full stop, he has placed the office memorandum dated 12th of July 2017, which provides that full superannuation pension shall be determined at the rate of 50% of last month's emolument drawn or 50% of last 10 months average emoluments, whichever is beneficial to the employer. As such, he submits that the amount of pension calculated by the authorities, that is rupees 15,770, which is not 50% of the last drawn salary, is wrongly calculated. And he claims that the pension should be more than what is provided for. Mr. P. Sharma, learned counsel for the AG. B. Sharma, learned counsel for the Accountant General, submits that the law relating to payment of salary is that it should be paid at a rate of 50% of the basic pay of the employee.
Calculation is given out in the instruction which I have provided to you. And the calculation
Oh, yes, it's not.
last page.
So as such, the basic pay being basic pay is where? Oh, yes, 31,540. 50% of the same would be 15,770 as allowed by the Office of the Accountant General. Accordingly, the submits, there is no miscalculation of the pensionary amount allowed to the petitioner. There is yet another grievance raised by the petitioner, and that is the department has made recovery of an excess amount. This is a recovery is made by the department or accounts.
We have instructed the treasury to recover it. We have not recovered. And that instruction which we have passed is based on the direction by the parent department. The parent department informed us that there was an overpayment of 46,000 in terms of based on that we have acted. We are just the implementing authority of the departments.
Okay. Hello, recoveries. It is stated by the learned counsel appearing for the accounts for the Accountant General that the recoveries to be done is asked for by the parent department and on the basis of the said instruction, the accounts officer deducts the same and informs it to the treasury, right? And informs it to the treasury department.
Instruction of verified, instruction dated 27 to 25, last paragraph. Last paragraph of the first page. It's clearly stated out there. Accordingly, the treasury officer was instructed to recover this amount from the DCI. She's got it.
No, where is the last paragraph of this instruction? No, I have this instruction.
That is
27.2.
It's 27.2. The last paragraph.
Yes, accordingly, treasury officer was instructed to recover this.
However, regarding the recovery of
CRG, okay.
overpayment of rupees 46,800, 13 from the DCRG, the same was done on the strength of Form 19 of the pension papers, copy enclosed therein. The DDO has specifically mentioned that overpayment of pay and allowance in RO, the petitioner is rupees so-and-so, which needs to be recovered out of the amount of DCRG. Accordingly, the treasury officer was instructed to recover this amount from the
Mr. B. Sharma, learned counsel for the Accountant General, further submits that the recovery of the overpayment was to the tune of rupees 46,830 from the DCRG on the strength of Form 19 of the pension paper. wherein the DDO, the disbursing officer, drawing and disbursing officer has specifically mentioned that overpayment of pay and allowance in respect of the petitioner is 46,830, and the same needs to be recovered from DCRG. And accordingly, the treasury officer was instructed to recover the amount from the DCRG. The submission of the learned counsel for the petitioner, that's some 6,87,807 was recovered, is incorrect in view of the
Whatever amount that has been deducted without my lord, figuring out the amount, my lord. Whatever amount, if any deducted, my lord, that has to be returned back, my lord. That's all, my lord.
No, that was overpayment that was deducted. Why will it be returned back?
No, my lord, in view of the law, my lord,
Is
laid
it
down by
supposed to
the
be
court,
returned back?
that cannot be, my lord, that cannot be recovered, my lord. Lordship, I have placed the judgment, my lord.
You will have to satisfy this court whether it's recovered.
And
Since there is an overpayment, my lord.
Even, my lord,
It is overpayment.
no, my lord,
Okay.
even recovery can be waived. That was the scheme also say, my lord. Lordship, I have placed the
But this
judgment.
is
Can you-
your overdrawn, this 46,000. So that will be recovered,
No,
recovered.
that was nothing mistake on my part, my lord.
Hmm.
Had it been the case that some foul play has been committed on my part,
But I don't write that.
that will be something different, my lord.
Petitioner protocol. Hmm. It has been recovered.
And in view of my lord, that because of the judgment laid down by the Honorable Appeals Court, my lord, there was a
Mention about those.
scheme also, my lord. That can also be waived, my lord.
Then, my lord, it will be multiple revisions. My lord, I probably might fail, my lord, Rupik Magic judgment say that there.
After Rafiq judgment, subsequent development is there, my lord. Certain guidelines has been laid down, my lord. That's what I placed the judgment, my lord.
Okay, I'll record.
Rupik Magic judgment.
This has been recovered.
Rupik Magic is a land of the judgment of the regarding recovery, my lord. That when the main motto was, my lord, into all of the government litigants should not be suffered. If he raised that issue, my lord, then it would be the multiple reading he sought, my lord. He cannot be, my lord. So that will be the another aspect, my lord.
It is noticed in the communication dated 24/2023 that the total DCRG the total provisional DCRG paid to the petitioner. So the total DCRG was paid as 7,70,000, right?
It's calculated at 7 lakhs,
7,000.
7,200
DCRG required to be paid to the petitioner is calculated at 7,07,282.
Now, provisional DCRG that was paid was 6 lakhs
Out of
40,000.
Out of which provisional DCRG paid to the petitioner was 6,40,994.
Plus a recovery of 46,830. If lordships adds these two amount, it comes to 6,80,000, 87,807. That which is talking about, that recovery which is talking about.
Plus the recovery made for overpayment is rupees 46,830.
If lordship adds these two, it comes to 6,80,000, 87,807.
And by adding these two, the total recovery comes to, total amount comes to 6,87,807.
This amount has to be deducted from 7,07,282 and whatever remains will be paid.
Which has to be deducted from the DCRG amount, that is 7,07,282. And the remaining amount has to be paid to the petitioner as gratuity. As such, it is seen that the calculation done by the assistant account officer is not incorrect. in the facts of the case. In view of the same, as far as the grievance of the petitioner that the pension has not been properly fixed and with recovery of the excess drawing was wrong, is not correct in the facts and circumstances of the case. However, as far as the issue of non-payment of pensionary amount by the bank is concerned, it is directed that the Treasury Office who had received, who was given the approval order by the Accountant General Office may be sent to the, not me, be sent to the bank authorities who would make the necessary payment to the petitioner. The said exercise be done within a period of 1 month from the date of receipt of this order.
From the treasury, my lord, until and unless, my lord, we have needs at least 20 days, because, my lord, the branch has sent to the
And
CCP.
direct the treasury to give it to you.
Then we will forward to the CP, Centralized Pension Processing Center, my lord. They,
It is not like last line to Katasan, it is still within person. Within a period of 2 months. Yeah. It is further directed that the Treasury Office should send the approval letter to the bank authorities, to the CP centralized.
directly, they can send to the directly, my lord, to the Centralized Pension Processing Center or in our branch. My lord. If
To
they
the
send the
bank-
branch, then we'll forward to the
Or
Centralized.
the CPO.
Centralized Pension Processing Center.
Then after that, they will approve and then they will
Yes,
pay.
they 50 days time is required. madam.
Okay, bank authorities who will forward the same to the centralized pension
Processing center.
processing center. Who would give it to the bank authorities back, who would finally disburse the same to the petitioner. The Treasury Office is directed to send the approval within a period of 20 days from the date of this order, and the bank authorities to finally disburse the same within a period of 1 month,
45 days.
45 days thereafter.
To give the exact date of the evaluation has been completed. I'll give it to the court now.
The matter is, the case is disposed.
My lord, just one thing if I can, my lord.
Direction.
My lord, can you just, if your lordship permit me, my lord. So far, the calculation part, my lord, is concerned. In my humble understanding, my lord, it will include everything, my lord. Salary, including salary.
From the basic
Lord-
pay only.
No, lordship may kindly see that it is very clear, my lord. Emoluments, all emolument received, service benefits, whatever is received, that has to be 50%, my lord. Therefore,
I think it is a subtle fact, 50% on the basic pay.
No, lordship, that rules has been amended. That's what I have placed, amended rules, my lord. So let them verify, my lord.
Who will verify now?
That the authority will verify, my lord.
Department will have to do it.
Yes, my lord.
PHC, madam.
PHC.
That exercise has to be carried out because the rules say otherwise, my lord. That's why I have placed the rules, my lord.
Okay, what do you say, Mr. Sharma?
So far as my knowledge goes, my lords, it's sanctioned on the basis of the basic pay only. If there is an amendment, I do not know, because even my father had received the pension based on his basic pay only. There is an amendment.
Oh,
that I do
the
not-
basic pay only.
No, that's what the rule says, my lord. I'm not saying, my lord. That's what the rules suggest, my lord. Emoluments of the 50%, my lord. So emoluments include everything, my lord, including salary, my lord. Clause 4, my lord.
Okay, I'll make a direction to the PHA department to look into.
Scrutinize, my lord, but whether that they have calculated as per the rules.
Calculation, you write a line, I will incorporate somewhere. It is further directed that the parent department, that is Public Health Engineering Department, may PHA department as well as the Karbi Anglong Autonomous Council to verify as to whether the pensionary benefit would be calculated at 50% of the basic pay or the last drawn salary and make necessary rectification of the same.
I'm sorry for interruption, my lord. That recovery has been made, my lord. In fact, my lord, even without affording the opportunity, that is inconsistent with the rules.
After the other coming up with new grounds after my
No,
judgment is delivered.
Because the recovery has to be made according to, they cannot go beyond the rules, my lord. They have to at least.
I have given the finding if something goes.
No, my lord, I will be highly obliged, whatever lordship make a call, my lord.
No, it's okay. You're deducted.
But
I have said that
At least,
deducted.
addition to that, my lord, that there was no negligence, foul play on my part. There is already 4 years delay, my lord. That's why Supreme Court has said, my lord, if there is, my lord, delay in payment, my lord, and the rest has to be imposed.
Then you also write that further, the accounts department is also directed to the entire, everything has to be reconsidered.
Everything, that's what judgment I have just marked, my lord, paragraph. Just, I
Acha,
have indicated the paragraph.
is also directed to re-verify the deduction made to his DCRG, to the DCRG of the petitioner. Okay? Or it will indicate. To substantiate, you have given so many judgments. To substantiate his argument, the petitioner has placed various judgments of the Honorable Supreme Court as well as the High Court.
I am obliged, madam.
If I'm ready.
Obliged, madam.
Yes. If I'm doubtful.
So in this petition, you have challenged the inquiry report as well as the penal order of penalty lordship imposed.
What about the respondents?
She was here also.
Have they filed affidavit? Hearings are complete.
Yes, lordship, we have filed our additional affidavit as well recently, lordship, 126 lordship.
So what about respondents? Call them. Mr. Chutia will appear.
No. M. Borua was there probably, lordship.
M. Borua. Yes, Mr. Chutia, are you there in this matter? Are you ready with the hearing or? Otherwise, you appear for all the respondents.
Yes, madam.
What else? Inquiry officer also.
Yes, madam.
Pension, all pensions.
Director pension also, madam.
Heard, Mr.
W. Rahman on behalf of A. Sharma.
W. Rahman on behalf of Asia for the petitioner and Mr. T.C. Chutia, learned counsel for all the respondents. Mr. On a joint prayer made by the parties, list this matter for admission hearing on, when do you want, Mr. Chutia? On 28th of April.
Can it be the joint prayer may not do it?
As prayed for by the learned counsel for the respondents, list this matter on 28th of April.
Hello. In the admission column only, not.
No, admission hearing.
Hello.
Yes, 21, Mr. Ha.
My lord, this pertains Pension matter, your lordship.
The Perusi last order final. Lordship, they were directed to file appropriate application manner before the competent authority. The next of kin certificate where it has been shown that he is the second wife. So that the pension may be processed. So whether he has done that.
Yes, my lord, your lordship may kindly come to page 14, your lordship.
Acha, wait, I'll just see the order.
In persons, the order, asked on the last occasion.
Okay. So you had submitted the next of kin certificate.
But thereafter, the petitioner on several occasions approached the competent authority for obtaining the fresh next of kin certificate. Now, they are saying there is no option in the computer section. In the online system, there is no option for second wife. So they are not issuing next of kin certificate. And here their only ground is that in the next of kin certificate, it is not mentioned that the Sajida Bibi is the second wife. First wife died earlier. Admittedly, she is second wife.
But without next of kin certificate, how will the office for?
Your lordship may kindly peruse page 14. This is the next of kin certificate.
Yes.
At serial number 1, Sajida Bibi.
She is who?
She is the second wife.
Oh,
First
she's-
wife died earlier.
Acha.
Now they are saying that Sajida Bibi, a relation wife, here should be second wife. This silly things, your lordship. Admittedly, she is second wife.
There are no
And-
children from the first wife.
There,
Yes,
and that is why, my lord.
their names are reflecting. Their names are reflecting, my lord. Zahirul Haq.
From the first wife, second wife not reflected.
Yes, yeah, here reflecting.
Yes.
From the first wife, serial number 225. They are the children. And
You
from-
are saying that, but it is not reflected in the document.
Yes, madam. The
And 6 and 7 are the children of the second wife.
second one.
So what needs to be done? Anyway, this pension amount will be distributed.
Yes, my lord, only that.
Monthly
there is
family
dispute,
pension.
Regard, with the son of the first wife, there has been some dispute. That is why, my lord, it not be processed, my lord.
At least
And-
monthly family pension should be disbursed. Without money, how she can survive, your lordship?
Because of that, my lord, the matter has come up in the mediation, my lord, center.
But son is 27 years, 22 years, they are not liable for pension.
Yes, your lord.
They are not entitled to pension.
They are claiming for, my lord.
They can.
Not only
Unmarried
the
daughter-
DCRG,
Yes, your lord.
And minor son.
Fine.
not pension, my lord, but the other benefits, my lord, they are claiming for them. And also, he has not made them a party.
Okay, have you filed your affidavit?
No, my lord, it was based on instructions. It is not defined. Only that the matter has come up in the mediation also, but the second member of the petitioner didn't appear, my lord.
Why did
It
you
had-
appear in mediation?
it had been-
On occasion, they appear.
Then why not the second occasion?
In second occasion, my lord, some dispute arose between the children from the first wife and the petitioner. But the petitioner has no objection in disbursing the amount or whatever the family pensionary benefit. But monthly family pension cannot be disbursed with the children from this.
Except the number 5, Ismail Haq, and the daughter, Amina Haq. Others are not entitled to get pension.
No, no.
Right. So the dispute will not have any effect.
If possible, my lord, it can, other fund, GPF fund, and that can be disbursed.
To the petitioner, why?
To the children of the first wife also. But monthly family pension should be given to the wife and minor children. That direction may be given. Otherwise, she's suffering.
We have not made them a party, my lord, so.
Not required, my lord. Here in the next of kin certificate, all the names are reflecting next of kin certificate.
But then there is a court's order, you have to file an application. But since online, there is no option for second wife. But then even if there is no option, it will not be mentioned.
Then your lordship may kindly direct to issue next of kin certificate. They are not issuing that there is no my lord, a column for second wife in the online system.
But otherwise, this next of kin certificate is okay.
This is not disputing.
First wife has predeceased the husband, so Sajida Bibi is the wife.
Right.
Due to, my lord, some documents, my lord, he is not placed before the authorities, my lord. That is why, my lord, has been.
What documents, my lord? All the documents are placed. Your lordship may kindly peruse page 16, your lordship. Next of kin certificate, my relationship proof along with children, my bank passbook, etc. What documents are required? These were.
Sorry, what happened? Why rejecting Robert? Where is the interim order?
There is no rejection, but they are holding up the process of family council.
Something to show that they are holding up. Where is that? Nothing.
Nothing.
First, final affidavit, then we'd like to bring this on record, my lord. That.
Or otherwise, I can direct the authorities to give pension as per the law.
My lord.
Wife and unmarried daughter and
There is a dispute, my lord. That is why they will come up again and they will seek relief for the other pensionary benefits, my lord.
That can be disbursed. Your lordship may kindly direct the other pensionary benefits, GPF fund.
whatever it is being
That can be disbursed.
for, they will provide.
My lord.
And there is no order, he has said that it was rejected or anything.
My lord.
Then due verification may be done with the documents, my lord, before releasing.
So your
It will
penal
be-
department will send the documents to the pensionary department, or what is the process? You have
Disbursement will be done by the treasury officer, my lord. Finance is here, which made a party.
No, it's okay, but then the parent department needs to send something.
Yes, my lord.
You are working under which department?
And that's
I mean,
animal husbandry and veterinary department, your lordship.
so did they send the required information to the treasury? Or to the AG? Who?
Government authority will know that part, my lord.
The proposal was not sent, my lord, because of the insufficient documents, my lord. That is it.
Proposal has to be sent by your office. You sending will not be enough. You need you send. Honorable Manager, Government Sheep and Goat Farm at Panbari.
On the last occasion, my lord, Musari was appeared and he submitted that only because of this next of kin certificate. According to them, this is defective. This is not mentioned as second wife.
Acha, you
Only
find
with some.
it without those necessary particulars, I cannot pass the orders. The other side said that only because of lack of this next of kin certificate. So bring those on record. Yes, ma'am.
Short that may be given.
Heard Mr. H. Hawk. What?
A. Rahman.
A. Hawk.
A. Rahman. Rahman.
A. Rahman, learned counsel for the petitioner, and Miss
B. Bora,
B. Bora,
respondent number 4 and 5.
as for respondent number 4 and 5. You have what? Is a borrow for the respond number 1 and 2. The grievance of the petitioner is that the grievance of the petitioner is that she being the second wife of the employee, late Amir Hamza, who was working under the establishment of government sheep and goat farm Panbari, were not given the family pension. In spite of submission of the next of kin certificate. It is the case of the petitioner that the first wife had predeceased her husband. And that she is the second wife. And she has one minor daughter and one minor son. That she is entitled to the pension, family pension. Ms. B. Bora, learned counsel for the respondent number. You are for BTC. Well, learned counsel for the BTC. Prays that she may be allowed to affidavit, bringing on record the facts that the petitioner is not shown as the second wife of the petitioner, of the employee. Prayer is allowed. List this matter on 30th of April. We will be too late. List this matter on 24th of April.
Master class.
27, my lord, can it be?
Okay, 27th.
I'm deeply only.
Made to the lordship. My lord, in this matter, my lord, the petitioner is made to representation before the authority for his promotion from grade 4 to grade 3, my lord. And day before yesterday, my lord, my certain development has taken place, my lord. My application has already been forwarded by Sinaki. I'm not really sure.
The application has been forwarded.
Yeah, my lord, though I made the presentation to the executive engine, but you can have a look. Yes. With the application of the promotion to the post of grade 3, so from master on grade 4, and this is under executive. So with reference to the so received from the executive engineer PW Gauhati so with reference to subject headed above, I have the honor to forward here with the copy of a letter along with its enclosure for promotion to the post of grade 3 in respect of the cylinder of grade 4. PW Gauhati Territorial Division for your favor and disposal. So, my lord, my representation lawsuit will file at page 7, my lord.
It's forwarded.
Yeah, my lordship page 29, NHS 7, my lord. My detail, all the communication, office, my lord. This last representation is pending before the authority. This mine application has been forwarded by my retirement only 2020, and I'll be retired, my lord. I joined 1991. And my service has been regularized 2004, my lord. More than 20 years I'm in service. And my process is till now, my lord, the representation has been before the full consideration. And they have decided this forwarded for consideration of this. So, my day, my lord, my representation is pending before the authority concerned, my lord. Then they're doing a logical, come to logical and pass a speaking order on my representation. That must have they will decide on my merit of that person.
That is-
Instead of keeping pending, my lord.
But Mr. P.K. Decker, learned A, Bothakur. R. Bothakur. A. Bothakur, learned counsel for PWD. For PWD role. The petitioner has filed this application under Article 26 of the Constitution of India, alleging inaction on the part of the respondent authorities in not considering the promotion of the petitioner from grade 4 to grade 3 fixed. It is the case of the petitioner that he was appointed to grade 4, right?
Yes, my lord.
He was appointed to grade 4 division in grade 4. No, he was appointed as grade 4 worker,
MR worker, master.
a master roll worker in the year 2000,
My lord, it is though it is represent 89, but it is official record 91.
the
Right.
year 1991. Thereafter, his service was regularized
2004, my lord, June 2004.
on
4th of June 2004.
2004.
Yes.
And since then, he has been working in the said capacity.
Yes, my lord.
He made an full stop. He made a representation. This is the first or second?
My lord,
representation?
first one is page 27, lecture 6.
He made an representation to the Executive Engineer Public Work Department for promotion to grade 3 post on 19/8/2023.
Yes, my final representation, page 29.
What happened to this representation? Not
My lord. Then again my second is a final.
which was not considered by the competent authority.
Then I again,
As such, he submitted another representation on 22/1/2025,
yes,
stating inter alia that he has been working since 1989 and in the said department, and that his colleagues have been promoted to the senior post excluding him. Full stop. He submits that it is provided that an employee who completes 15 years of service in the department gets eligible for next promotion, that is to grade 3 post. And since he has completed more than 15 years,
more than 20 years.
more than 20 years of service as grade 4 employees, he should be considered for promotion to grade 3 post. The learned counsel for the petitioner submits that he received that the petitioner received a letter addressed by the additional chief engineer PWD roads, addressed to the deputy secretary to the government of Assam, PWD road, forwarding the representation of the petitioner for promotion to the post of grade 3, and a request is made for kind disposal. In view of the same, and in view of the eligibility, and in view of the fact that the petitioner is eligible for promotion to the post of grade 3, this court directs the authority concerned, that is Executive Engineer PWD Road, Jorhat and Titavur Territorial Road Division, to consider his application and to dispose of within a period of 2 months from the date of receipt of this order.
Give play of license.
Petition is disposed of.
Give play of license.
Okay. Yes.
Lordship, if you may produce the last order dated 22/2026, respondents were instructed to.
Yes, you have received instruction and you are supposed to file an affidavit. What happened?
No, it's
okay, then you.
if the inspection is that, they have to signature. Then only we can take that.
In fact, Lordship may pass order, Lordship, directing the authorities to do the needful, because the initial
Will be sent to us, we can.
because Lordship.
You have not sent.
Lordship, we have submitted the pension proposal, Lordship, that instance I have to take, Lordship, whether.
Fresh.
You are for the treasury.
For the accountant.
Accountant.
A fresh proposal is to come for the.
So you send the proposal.
Lordship.
And I'll make all the necessary for it.
Mr. Upadhyay, learned counsel for
Irrigation department.
irrigation department, submits that he would take instructions to the effect that proposal for pension
Pension.
Pension he's already getting, he wants that one to be revised pay.
On the revised ROP.
In fact, Lordship, initial 6 years period were deducted when the pension was calculated. Lordship. Now, Lordship, after
But
the
this 6 years thing is gone.
gone, that is the Lordship, that is the thing. No.
Acha, as to people, to be effect making. The proposal for pension on the revised pay was sent, was
Was to be sent to the AG. Lordship.
today, we will take the instructions, right? As to whether,
Yes.
as to whether proposal has been sent to the Accountant General Office. As such, to list this matter, when can you bring it?
Lordship, after due vacation.
As I list this matter on 22nd of April
Lordship.
for necessary instructions.
Lordship. Apply.
This one I'll cut it.
Yes, Your Lordship. My lord, this case is relating to compassionate appointment, Lordship. Lordship, petitioner case was recommended by the DLC Karimgaj Lordship on 26/6/2023, Lordship. And while the case of the petitioner is pending before the SLC state level committee for further consideration, Lordship, in the meantime, one notification came into force, Lordship, which was issued by the government of Assam, Lordship, that no further appointment on compassionate ground shall be given, Lordship. And thereafter, Lordship, several.
I think, right?
Yes, Lordship, but my case was, Lordship, prior to that notification, Lordship, because, Lordship,
This case was already forwarded.
already forwarded by the DLC, Lordship. Lordship never rejected, Lordship. DLC recommended my name for a grade 4 post, Lordship, and it was sent to the government, Lordship, for further consideration by the SLC. And while it is pending, Lordship, before the government for further consideration, Lordship, that notification came into force, Lordship, that if for 2 years the case was not considered, then no appointment shall be given. So thereafter, Lordship, there are several writ petitions before this honorable court, and I have annexed one of those order, Lordship. Your Lordship may kindly come to page 46, Lordship.
Who's appearing for the respondent?
So
Such
my
case.
my case is only that, Lordship, only in the light of that order, Lordship. My case also may be only considered by the SLC, Lordship. Order dated 46, page 46, Lordship. Operative person starts from 47, Lordship. So here also similar, Lordship, on OM dated 18/9/2024, Lordship, that was bifurcated and directed the authorities to consider, as the case was already considered by the DLC, Lordship. So
No, case was considered. It was sent, I mean, it was directed that we should be inducted in some grade 4 post.
in the grade 4 course,
And then the matter was sent to SLC.
SLC,
During dependency, this happened.
this happened. So
And now you want the compassionate appointment, but
consideration, Lordship.
notification say,
Notification says, Lordship, if any application for compassionate appointment, Lordship, pending for 2 years, more than 2 years, then, Lordship, that would be spent its force. But in my case, Lordship, my case was already considered by the DRC, and it, Lordship, pending before the SLC. And no action was taken by the SLC. So only they may consider, either they may reject or accept, Lordship, anything, any outcome, Lordship.
what do you say, Mr. Chutia?
My lord, is a case of my lord died in 2002. After 24 years, my lord, the compassionate appointment cannot be given.
DLC.
No, but DLC may be recommended. My lord, subsequently, the development is there. My lord, another case, Development Tibari case has come also. Achut Ranjan Das case also there after 2002. So 2002, this immediacy is no longer in this case, my lord, because the immediacy is because after death of a incumbent, my lord, any person of the bed and of the family, immediately to give relief to get up from the trouble, that is the escape to give a compassionate appointment. Now 2002 died, my lord, till today 2024 has got. So after that, my lord, the immediacy doesn't come at all.
When did the DLC recommend your name?
Lordship, in the year 2023, Lordship. Page 30, Lordship.
So long.
Yes, Lordship. 26/6/2023, Lordship.
Why did it take so long?
Lordship, they may, because in the year 2013, I have filed a writ petition and this honorable court directed to consider my case. But all in the, this,
Do your father died?
yes, Lordship. And 2000, preferred a writ petition. This honorable court directed to consider my case as per usual process. Lordship. And ultimately in the year 2023, Lordship, my case was recommended by the judge. But otherwise, Lordship, I have running from pillar to post, Lordship, but I have no control over the meeting of the DLC, Lordship. Only a Lordship watcher. So, Lordship, as in the year.
So, Chutia, when DLC has recommended.
So DLC may be recommended, my lord, a Debabat Tiwari case is there, my lord. What's it, Debabat Tiwari case says? For whoever, my lord, fault, either in the party or in the respondents, government, after 2 years, my lord, no compensation appointment can be given. After 2 years, he has gone. Now he has 24 years gone. Anyhow, they have survived. So that is the motto, my lord, the Debabat Tiwari case is clear. Even it is also pending, it is also not covered. Debabat Tiwari case says, my lord.
Acha, DLC recommended in 2023.
2023.
You filed application with this one?
That was after passing of the honorable court's order, I think that were reconsider his case. That's why it's pending in 2023. Where long lapse of
Was it 2000?
December 2025, I have filed.
Huh?
December 2025, so I have filed this writ petition.
December 25, you have filed.
Yes, ma'am.
my lord, the ratio deficiency of the Debabat Tiwari case is where a long lapse of time has occurred since the death of the deceased employee. The sense of immediacy for seeking compensatory payment may not be considered.
This is the basis that you have survived for so long, so you need not be compassionate.
Do not consider, do not consider.
This is the basic.
This is the basic
But
one.
then, now that his case is recommended by DLC,
Maybe the DLC, my lord.
it's a expectation.
Maybe DLC, my lord, but Debabat Tiwari case for whoever lapse, my lord. DLC, why they have recommended so late? He 2002, he is, my lord, this is, his father died. Yeah, since 2002, why 2023 they have, my lord,
Made application for compassionate appointment when? After that?
After that, immediately.
2002, 3.
why he was sleeping over the matter, my lord?
Then why it had taken so long?
Lordship, this is the Lordship
Because your name will come in the list. And
wisdom of the DLC Lordship. Thereafter, in the year 2000, after so long, Lordship, I have filed a writ petition before this honorable court.
after DLC's recommendation.
No, Lordship. When my case was not considered, in the year, Lordship, that page 21 is the order, Lordship, 39/2013. So this honorable court directed Lordship to consider my case. Then also they have taken another 10 years, Lordship, for recommending my name. So there are no fault on my part, Lordship, although I have running from period, I have no control over that. And only fact is that, Lordship, my case was showing those reasons, Lordship, the DLC, SLC may very well, Lordship, rejected my case. But at least the case shall be closed, Lordship. Otherwise, that would be open, Lordship.
Directly SLC to consider and pass the speaking order.
And also direct it would keep some chaos, my lord. Because thereafter, after Debabat Tiwari case, my lord, notification has come. And 18 September 2024, this notification based on the Debabat Tiwari case. And that is also he has not challenged it now.
I have challenged, Lordship. Even I have annexed the order, Lordship. After that notification, that this order come. Lordship, notification is Lordship at page 41, Lordship. 41 is the notification, Lordship. 42 is the operating portion, Lordship. Last paragraph. In view of the circumstances mentioned, it has been decided that no cases for appointment on compassionate ground to the family members of state government employee who died in harness or retired prematurely on being declared permanently incapable for being or missing and whose whereabouts is not known prior to 31/3/2017 shall be entertained by any administrative department authority for any reason whatsoever for the for place before the SLC or DLC for recovery.
Candidates for appointment. So your case is covered. Your person has died before 2017.
Yes, Lordship. So that's why, Lordship, I have challenges
So
this notification.
no cases for appointment shall be entertained by any administrative for recommendation of compassionate. The cases of employee died in harness after IMA have been taken care of by compassionate family pension scheme. So what? It goes against you?
Yes, Lordship. That's why I have challenged this notification because, Lordship, only and even after this notification, Lordship, some of the persons also challenges that notification. So thereafter, this honorable court direct that a fresh decision shall be taken upon the lordship because this is only a consideration. No, in other cases, I have annexed similar order, lordship, page 46, lordship, annexer 13, wherein this honorable court directed the authorities, even after considering the OM dated 18/9/2024, this OM, lordship. This honorable court directed
After that, my lord, what happened?
to consider.
342 of 2024, this is the long batch of information was disposed of, and advocate general appeared. The consented order was passed, and those case was pending before 3/4/2025. Those were pending, and pending and challenged. The office number dated 18/4/2024. This case was followed, disposed of, sending to the SLC and DSC to consider on the basis of and taking into account the developer body case also. And thereafter, no case should be considered. Thereafter, this SOP is executive instruction issued by the government that those who are pending case either in the DLC or SLC, they should apply a fresh, government will consider at a law. That is the right. He did not apply. His case is pending 2025. He did not apply. This was the last one of instructions, executive instruction.
My lord, your lordship may
He has no case at all. 2002 died.
My lord, your lordship may kindly turn to page 48, lordship, the order of this honorable court, lordship, wherein all the lordship measures taken care, lordship, while passing the similar order, lordship. Your lordship may kindly turn to page 48, paragraph 10, lordship. It is made, may I read it, lordship. Page 48, lordship, the order. Paragraph 10, lordship. It is made clear that in view of the consent of the parties, this court has not gone into the merits of any of the petitioner's cases that are being disposed of by way of this order. And as such, the applications for compassionate appointment should be disposed of by the concerned authorities on merit as they deem it fit and proper. The decisions to be taken by the concerned authorities should be based on reasons, and the decisions taken should be communicated to the petitioners thereafter. It is also directed that while deciding the applications for compassionate appointments, the respondents cannot take recourse to the impugned OM dated 18/9/2024. Though the judgment provided therein, that is the case of Devabrata Tiwari, can be considered applied by the concerned authority. It is again made clear that this order cannot be used as a precedent for cases that are filed on so and so and thereafter.
That please.
So, yes,
that is important.
Yes.
On 3/4?
It's 4/4/2025. So, and thereafter, but these, and since there are consensus at the bar that the petitioner's case will be covered by the aforesaid judgment and order dated so and so passed by this court, this petition is being disposed of at the stage of motion hearing by providing that the SLC shall consider the case of the writ petitioner in the light of the observations made in paragraph 9 and 10 of the judgment and order dated 3/4/2025 and take appropriate decision in the matter as may be permissible. So my prayer is only that, lordship, they may take any decision, lordship, as per prevalent rules. They have a very authorized to reject my case also, but that cannot be kept open, because it is not my fault that in the year 2023 my case was recommended by the DSC, because I have no control over any of the authorities. So only my prayer is that, lordship, at least my case shall be closed, lordship, finally.
Where is the recommendation by DLC?
Recommendation, lordship, the original minors, lordship, at page 30, lordship. Page 30, and my name, lordship, at page 33, lordship. Deputy Commissioner, Karimganj, column, lordship, second column. Page 33.
So, you are who?
Vishwajit Shukla, lord.
Yeah.
It has been decided to recommend the claim for appointment in the vacant post of grade 4 MTS found to be admissible as per the quota of 5% in the establishment of CO Jila Parishad Karimganj in terms of the para 15 of the government OM 16/2015 in compliance of the direction of the Honorable Gauhati High Court. So thereafter my case was further communicated throughout the department, lordship, and ultimately it reached to the government, lordship, for further consideration.
Any of these cases, no, adjournment cannot be considered.
So earlier it was rejected because there was no post. Now that there are some available posts.
The
See,
post may be ballot, but what is happening, ballot, Achuranjan case is also there. This Justice Biplab D.K. Sharma passed this order 30th of September 2013. They also said to examine the matter and feasibility of otherwise the case of the petitioner in terms of the guidelines issued by Achuranjan Das and Florian Nessa. Needless to say that the petitioner's case.
that SLC will decide upon after looking into the marriage.
No, ballot.
So what I'll direct is SLC
No,
will.
but
discuss his
to
application.
consider when, Malat, after the passing of this order, not three.
Not consider.
No, the
SLC will discuss of the
no,
application.
no, Lordship, Malat, this chain is, Malat, after passing the 342 petition, Malat, a batch of disposal. These are the executive instructions. Those who are pending in the court, you apply to the SLC, will see.
So I'll look at, there are some judgments and memorandums that I can see. So I will look into the matter and pass necessary orders later.
No, Malat, Hambu Service,
Chit case, Sari case.
not a fifth case to at all, Malat, the action. It is liable to be dismissed over 2002, Malat.
Otherwise,
Is it not under appointment is not a matter.
otherwise they are taking recourse of their own fault.
No,
Also.
Malat.
Because it is not my fault that I
Yes, maybe.
that was
maybe
recommended in the year
any
2023.
Developer body Lordship
Yes,
kindly-
this matter again for hearing.
Yes, I will come with a case law.
Here is, please me those cases. And chronologically, like after this notification.
Developer body case,
Huh.
Achuranjan Das.
Even
The
after
Lordship will go
Devotatu,
through it
there is
and I will-
another judgment of Canara Bank. Honorable Supreme Court directed, no.
Judgment.
Yes, so I'm sure.
One after the other, it's getting mixed up. So, I think was that, as agreed to by the learned counsels for the parties, list this matter again on when?
26th of April, Lordship.
So April was Sunday. 24th of April.
24. Hi, Logan. Lordship, as a part heard matter or? Okay, online.
Also, on the last day, notice was issued and the respondents were directed to obtain the instructions.
Mr.
HR does.
HR does. Learned, heard Mr. HR does, learned counsel for the petitioner and Ms. P. Gauhati, learned, standing counsel for PWG. Miss P. appearing on behalf of P. Nayak, who appears on behalf of Mr. P. Nayak. Ms. Gauhati submits that she needs some further time to get the instructions. Prayer is allowed. List this matter again on.
Lord, the date may be fixed, Lord.
Then the date.
Prior to the Bihu vacations, Lord. After the Bihu vacations,
Days is-
Lord. Any date after the.
So, 29th of April.
Obliged.
Okay.
May I please, Your Lordship? Lordship, in this matter, since long petitioner was not presenting matter, on the last date, I have asked to present some instruction. But the district minor, they are busy with the present ongoing election process. So I'm requesting to refix the matter after the election.
Yes, you are Mr.
As Doctor for Standing Council, PNRD Department.
As Doctor, learned standing counsel for PNRD department, seek some further time to get the required instruction. There is a law. List this matter on 29th of April.
Right. Hello.
Yes, Your Lord. This matter pertains to the illegal stoppage of the result of the 10th semester of the BA LLB course, wherein for the unfair means of using of tools and rankings, the entire result has been withheld and they have lost an entire year now. And now their examination for the AIB is scheduled on June. So if they are not being cleared, otherwise they will lose another year. Now the fact of the case hearing is that now.
When you already? Okay, make it short.
Yes. Now, worship hearing.
Lord, we come up for hearing, Lord, today is for admission. But otherwise, I'm ready.
Admission can be discussed.
It can be disposed of. My lordship, their contention hearing, now they have said that the petitioner numbers,
Petitioners.
they are
Students.
they are all students of the final semester.
Five of them.
Five of them. They have cleared their earlier semesters. Only the final semester has not been cleared because it has been shown that two handwritings have been used in the project. That is a 10.5 paper. There is a moot court wherein only 200 pages of a sheet where two handwritings were being used and detected. They have
How it is done, I don't know.
it is done through the project for whom
They appear in the moot court.
they have appeared. The moot court consists of the viva along with the other, including the chambers visits. All marks are included therein, not only the papers of these 200 pages. Now, this 200 pages worksheet has been done by them in the house and it has been submitted before the principal. It is evaluated by the principal and also by the teacher, the guiding teacher. Later on, they have to submit before the external. They were not being warned. They were not being warned regarding the use of any two handwritings. Later on, when the external,
Two handwritings.
it is a handwritten project.
So
And-
handwriting, how can there be two type of
They
handwriting?
have used their parents' handwriting therein for the 200 pages because it was too long. And they have,
It's handwriting.
yes, their handwriting is also there and their parents' handwriting is there in some pages.
Written.
Yes, they have admitted the same before the university also in their representation also. To take some corrective measures in regard to this, if required, they can also give a fresh 200 pages written project, but it was not being done, and rather their entire result has been withheld, and they were not able to give the AIB examination. Otherwise, they would have cleared the AIB and have started their practice. Now they have.
What examination, AIB?
This is the All India Bar Examination. These are law students. So now they have said that petitioner number 2 has not used any two handwritings. They have contended in their affidavit also. They are ready to declare the result of petition number 2, whereas it has not been done till today. It has been contended around 2-3 months before. And they
Petitioner number 2 has not used two
no,
handwritings.
she has not used any handwriting, and after we have written in the writ petition, they have contended the same. Yes, she has not used it, and now she has also suffered for it. She has also suffered for it, and the result has also not been declared till now. And from this is evident from the fact that they are chosen for a clash between the principal and the students. There was a clash for their some regarding the staff elections. In their student election, there was a clash between the principal and the students, these particular students, for which their result has been withheld.
But in respect of other students, there were two handwritings.
There were two handwritings. It is an admitted fact. They have also admitted. We are not denying it.
There is no illegality in it.
Now, worship is my contention is that the entire project consists of different things. The whatever has been written in the project is their own concept. The data that has been entered therein is a original concept, their own research, and they have also visited the chambers and done all the practical works by themselves. Only use of the handwriting of a certain parents in some 3 or 2 pages.
Parents' handwriting be there.
It has been written at home, Your Worship. It is clear by them. It is a 200 sheets of paper that is submitted before the court.
He is the student, how will the parents write?
Now, this has been written by the students from home and been submitted before the court, before the principal during the moot court, and the marks has been assessed from therein. And that particular subject not only includes these 200 pages, it also includes the viva also. It also includes the chamber visit works and other practical works that have been given to them. If anything has been found therein, the illegality in the use of two handwritings, some marks could have been deducted there. And rather doing that, they have been withheld. The results have been withheld.
What are the guidelines? Yes, Mr. Fukan, what is the?
My lord, I take your lordship straight to page 61, my lord. This running page 61. My affidavit. That's per direction of this.
You are freelancing only that, right?
Yes. Now thing is that whatever decision was being taken, neither the notice has been served upon us. The so-called has been shown directly. Our
Results were written.
Yes.
And then
Without-
you do not appear for the bar exam.
No, not a single notice has been issued to us. After giving our representation to the university, thereafter only we are being called by the university. We were called in. Only the petitioner number 3 was asked to submit. No other can use their speech. They are only petition number 3, representing the other petitioners submitted before the people who are present out there. And they have admitted there, and they have also asked that if required, they will write it again. But no, they were not being liberal enough.
That 200-page project is away, apart from the Vagabosi,
Yes.
and all those, right?
Yes.
The visits to the chamber.
Yes.
Those are different. This 200-page project is.
This is the entire one subject. This is the entire one subject comprises of all these different contents. The marks comes evaluation containing each and everything in one particular subject. And
What subject means?
10.5 paper. That is the moot court.
Things have become so complicated.
Moot court and internship.
Not the one that we had passed.
Is that moot court and internship paper of 10.5? Paper 10.5.
Whatever it is. So what is your case? What?
Page 61, paragraph 4. Few lines. That this department humbly states that as per the recommendation of the unfair means committee meeting held on 4/11/25, except the writ petitioner number 2, Srimati Dulmani Das, bearing so and so rule number. All other writ petitioners, that is writ petitioner number 1, 3, 4, and 5, shall have to reappear in the paper moot court and internship 10.5. In view of the confession of having taken external help in writing the practical copy and written admission made by them.
So you were allowed to reappear?
No.
They were not expelled, not debarred from appearing in any examination.
Now, Lordship, this repetition
part
was
of the university authority,
Huh.
that they will have to reappear.
So reappear.
Lordship, 1 year has already been gone there. We have filed a writ petition in 2025, and they were being asked to file their appealable since then in contention to our writ petition, which was being unfair to us. Now they have also contended that Dulumani Das has not done anything with the 2 handwritings. Now, what
The unfair means committee meeting was in November 25. So there only it was decided directly due to reappear.
for that only we have come before this court, because use of 2 handwriting till date, nobody has been expelled from the particular examination.
Expelled, we said.
The withheld is equivalent to passing of the 1 entire year, and they have been.
Want to reappear.
No, already the moot court for the next year has already been begun. Now we will again lose another year. And last occasion for interim also, we have paid for the AIB examination when there was a shortage of time for 2 or 3 days for the last day of giving the examination, for which no steps should be taken. So another now AIB examination is there on June 2026. And again, we will have to, if we go for the moot court again, then we will have to again appear in the next year of AIB examination.
If you appear in a moot court thing this year,
Yeah.
in 27 you have to appear for the examination.
For these
only 1 year.
small things.
If they are expelled, then entire 5 years.
Now, Worship,
So you are not expelled.
this small issue of having a 2 handwriting, they're also not a kind of cheating.
Small issue. Why do your parents write there?
They could have been taken a reformative measures of writing the entire pages for within that specific period of time. It was not been done. Rather, entire year has been withheld. In the last occasion also,
Handwritings are allowed.
it is not only them, all the students do there in there. And they were on the last occasion also, the Lordship was also viewed.
2 handwritings were used and they have passed.
Yes, Lordship. And last time also
Understand
in
the
the
handwritings business.
in the court of means UK, Justice UK and I also said it has been too harsh to them in regards to the steps that have been taken to the.
See, you are the student. You have to compete. You have to do all the struggles. Now, if your parents write, then how can that be a kind of an examination or a project?
For that reason, Your Lordship, some marks would have been deducted because that is the paper which included everything.
Are there any rules, regulations?
That unfair means committee meeting. Since simply they adopted unfair means. They have admitted the 2 handwriting. Plain and simple.
Now, Lordship, I would like to bring into attention something about it.
Where is the impugn order, whatever, what have you challenged? Nothing.
We are challenging, Your Lordship, the.
Any speaking order, anything?
No, there is no speaking order, Your Lordship. There is no speaking order. We are challenging the, at the page 45, the result, the notification was being given in the online. That is the thing.
Your result is stopped.
Yes. These are, and we were asked to communicate. Then I would like to bring into attention, Your Lordship.
What relief you want? Do you reappear?
No, Lordship, we want the results to be declared considering our paper. If certain marks can be deducted, then we have no issues, Your Lordship. Now,
Certain marks will be deducted.
now, Lordship, one thing.
This is unfair means, and it is for the.
If there was any unfair means, Your Lordship, that should have been communicated to us. It was being verified. There is a verification in the process.
50 and 51, notice, issued to them, page 50 and 51 of the revision. Notice was issued to them on 22/10/2025 itself. And they have admitted in writing.
So you have attended the office chamber of the controller exam?
Yes, after giving our representation only, we are being called for. We have appeared therein, and we are not being asked to submit ourselves. Only one of the petition was asked to submit on behalf of all of them. And I would like to, Lordship, we come to para 5 of my petition, where therein I have stated the petition has completed board and submitted to college. The papers remain under the joint supervision of the subject teacher and the principal. In fact, the practical papers contained a section titled certificate, where the teacher and the principal jointly certify everything was in order. Now, although it was checked, signed, and returned the papers to the petitioner, instructing them to bring the practical papers on the day of the final examination from the para 8 of my petition. It's para 8 of my petition, Your Lordship, at the lower bottom. These papers remain under the joint supervision.
So this relief of declaring the results would do. You have to reappear.
Your Lordship, if I have to reappear for the exam, there is also some mistakes on the part of the staff also, on the principal also. Why they have verified the same and checked and asked us to bring before the external during the final examination?
Doesn't matter if somebody does wrong, you will also do wrong, and then it will all be condoned. No.
If they should have been warned, they would have rectified it. Why should they only suffer for this mistake? It was being verified by the principal and the other staffs, the guiding teacher.
You know, my learned friend's argument would be the negative equality.
Yes, somebody has done wrong, and you also have done wrong. So
Allowed to prove that law.
cannot be.
Actually, looking into the students' career, Lordship, they have already lost a year. Now, if they are not being allowed to, the results being not being declared, they will
Show
also.
me something where two handwritings are permissible.
So,
It's nothing.
if not permissible, if they can show it, Your Lordship.
Yes, Mr. Pokan, nothing. No, in a particular project of a student, how can someone else write? How can there be two handwritings? This is totally an unfair mean. Like I remember in our school days, projects are being allotted to the students and parents does half of it and then we do half of it. But then it will not be known that parents have done. But that is an unfair thing.
There should be some limits, now, purity in the examination. Otherwise, it will open a floodgate.
This is not something sitting in
And
the
they have admitted
examination.
themselves.
This is dismissing.
This has been done they have been doing the project from their home. And this is not the practice that has been done by them alone, you know. So they have also included petition number 2 also, but she has not done anything in this.
But then two, she need not reappear. Two, they will do something. What?
Below the second paragraph, page 61.
If your Lordship may do a favor, Your Lordship, they may be asked to submit the particular, whatever the 200 papers within a specific period of time, so that the results may be thereafter it may be declared.
That can be done.
Yes.
They will be reappear means what? Reappear in the moot court. So that will be too okay. They will submit 200-page project again.
Yes,
Within a
a
reasonable
time within a reasonable period of time, they will be asked to submit the same. And also, time will be given to them to evaluate the same, and results may be declared before that, so that they can appeal.
That can be done, Mr. Pukan, instead of again making them lose use. Right. And direct them to again submit 200 pages project, and then it will be reevaluated by the authorities.
There is a time limit. I don't know exactly.
This will be taken as an exception. Right.
And number 2 may be excluded from it.
Number 2, what are you planning? What are your number?
You are ready to declare the result of number 2.
Where is that?
Below the, since you know that paragraph, sub-paragraph, two of paragraph 4, this is Mary. She has been examined. On the other hand, after reviewing the internship report of the aforesaid Gunamani Das, petitioner number 2, the committee members concluded that the student's report contained variation in the handwriting, which is due to her ability to write in different fonts, which she demonstrated in front of the committee members. And as such, she has been exonerated in the incident.
And her results will be declared. If not declared, I'll make it, I'll direct them to declare. Okay, heard, Mr.
Yes, ma'am.
S. Ahmed, Learned Counsel for the petitioner, and Mr. P.J. Pukon, Learned Counsel for Gauhati University. By this application filed under Article 226 and 227 of the Constitution of India, the petitioners have challenged the arbitrary action on the part of the respondent authorities in withholding the final 10th semester examination result of the petitioners in course of BA LLB of the session 2024-2025. This is 5-year course.
5 years.
Okay, questions. The case of the petitioner that they have passed all other semesters with good results, and they finally appeared in the final semester examination of BA LLB for the course or for the sessions 24-25. And the results were declared on 12/8/2025. However, the petitioners stated that they came to know from the website of the Gauhati University that their results are stopped, and they were directed to contact the university authorities. As such, the petitioners approached the principal of the law college, and they were apprised that external examiner reviewed their practical copies and observed 2 different handwritings, which led to the action of stopping the results. They were further informed that there was no issue regarding the other subjects, and that the said action was taken only for paper 10.5 within bracket moot court and internship, for which it is alleged unfair means were undertaken by the petitioners. Unfair means were adopted, not undertaken, were adopted by the petitioners. Being agreed, the petitioners submitted representations to the authorities concerned, which however was not considered by the authorities. Thereafter, the petitioners forwarded a representation to Gauhati University, ventilating their grievances. Wherein they had admitted that they had submitted practical papers with 2 handwritings. And also that there are other students who had submitted papers with 2 handwritings, and they were declared passed. the petitioner has also raised their grievances that before stopping the results, they were not heard. The petitioners also admitted that due to time constraint, they could not complete the 200 pages project and that they had to take help from their family members in writing it down. And that the entire research, analysis, and ideas were of theirs. Were of PATIRS hospitals, were of theirs. And that the family members had merely assisted in writing. The learned counsel for the petitioner submits that the petitioners who had actually not adopted any unfair means. It is only due to time constraint that they had taken help from the family members. Were acted harshly upon, and that they would lose years and they won't be able to appear in the what examination? Bar examination.
India Bar Examination.
All India bar examination. Which would have a disastrous impact on their career. He submits that instead of stopping the results and directing them to reappear in the moot court, other measures could have been adopted by the authorities. Mr. And what else? These are your submissions, right? Yes. Mr. P.G. Puppa, learned counsel for the Gauhati University, submits that the Unfair Means Committee held its meeting on 4/11/25 and found the unfair means adopted by the petitioners and directed the petitioners to reappear in the paper Moot Court and Internship within bracket 10.5 in view of the confession and written admission made by the petitioners that they have taken help from their parents. However, the respondent authorities have exonerated petitioner number 2, whose paper, although showed 2 types of handwritings, but those handwritings are of petitioner number 2 herself. Is she a girl?
Yes.
Petition number 2 herself. It is seen that the petitioners have admitted in their defense that they have taken help from their parents in writing the 200-page project of moot court and internship, and that those written contents are the results of their own analysis and research, and that parents had only helped in writing the same. This court takes a lenient view. And in the fitness of things, this court directs that the petitioners be allowed to submit their 200-page project of moot court and internship afresh. Must submit afresh before the authorities, before the before the examiners, before the, I forget what.
Principal law college.
To the examiners of the law college who would consider the said project within a period of 2 months. No.
Otherwise, it will be too late. We have already sent it to.
It's in the academic arena.
Oh.
Court is also.
Within a
So, my lord,
Yes.
as early as.
days of submission of the project.
It may be, the project may be submitted within 20 days.
My lord, the time frame may not be fixed by the Honorable Court since the academic arena.
No, otherwise they will receive over it and
Yes.
again
As early as possible, my lord, before that AIB examination. That will be
before the AIB.
AIB examination.
Otherwise,
He's-
otherwise they won't be able to apply for the AIB also. They will, that factor will have to.
Before the applications intended to be
Submission.
taken from the students for AIB.
The principal.
Who would submit before the examination law college within a period of 20 days. Within a period of 20 days, and the concerned authorities of the law college would examine the same and declare the results before the applications are asked for the AIB examinations.
Last date of submission of the AIB examination may be reported. Otherwise,
The last date of submissions for before the, it's okay before whatever I said, content, before they were asked for. Before people appearing for the AIB examinations.
The principal of Nagaon Law College will coordinate with the Gauhati University examination of the academic.
Further, the principal of Nagaon Law College would coordinate with the authorities in the Gauhati University in the said exercise. Petition is discussed.
and direction will be given to them so that they can appear before the AIB that will be held in June.
Okay, enough of relief I've given, otherwise they should have.
This AIB examination will be further, it will not notify the
Before the
2020.
applications,
On June, the AIB examination is scheduled.
so I've said before the applications are sought for AIB examination.
For that is scheduled on June 2026.
It's okay, before that it will do.
Thousands of students appear. Five applications. And the university authorities have taken.
Because the
cost time. Otherwise, they would have taken that 5 years course again.
So they are lenient enough. It's a, the case is disposed. Phase 3 and 4 लिखे देगा, heard the लिखे सा, Mr. 834 respond number 4. And you? That's for 8 respond number 4, respond number 2. No more disposals now. 47. Yes, 47. No more disposals. Yes. Careful.
Respond number 4. Yes, sir.
Learned counsel.
Yes, sir. For
Yes, sir. Learned counsel for respond number 4. Seek some further time to get the instructions. It is allowed. Use this matter of.
after
Use this matter on 27th of April. Oops. None appears on call for the petitioner. This matter again on. Again after 4 weeks.
I think
30.
Lordship. No, in 29, my lord, I.
29 years.
In 29, my lord, I am paid for some time. I have not received the instruction.
And so petitioner said is not there.
Petitioner, CC appears for the petitioner.
He didn't come forward when the matter was called. Okay, me cut it out. Third miss. Empathy. Empathy, learning counsel for the petitioner. And Mr. Dina for his phone number.
No, on last day, Lordship has directed me to have the instruction. Otherwise, the respondents who are make the petition, they retire longer. And for the state, I'll take the instruction.
Okay, Mr.
I have not had the recover.
Dina, learning, he is senior government advocate. Who prays that he seeks some more time to get the instructions. Prayer is allowed, list this matter after 2 weeks.
No.
Lordship, may go through the last order here, Lordship.
Yes.
Mr.
Yeah, senior Mr. X is out of station for some busy. And then both of the times, Lordship may fix a short bit.
Miss
I did it.
R. Devi, learned counsel appearing for Mr. H. Homo, learned counsel for Gauhati University. For my course.
For SPC.
What?
STC.
Assam State Transport
For
Corporation.
ASTC. Miss, the learned counsel for petitioner submits that the conducting counsel is indisposed and has paid for some time.
Come from the respondent.
Respondent, huh? Responding petitioner, no. Respondent. Prayer has paid for some time. Prayer is allowed. List this matter on. You said 31st. It is this matter on 8th of April.
Obliged.
Mr. Das,
Yes.
no more disposal. Tell me what it is.
After vacation.
As agreed to by the parties, this matter on 30th of April.
Fine. I leave.
Minor. I am not petitioner. Kindly see the last order. Respondent was supposed file affidavit.
Yes.
Instruction is obtained, Lordship.
Instructions are okay.
Time limit.
Instructions are okay.
Obtained.
You have to file affidavit.
No.
Mr.
Killed.
A.L. Gupta, learned counsel for respondent number 1 and 2, submits that he has received the instructions and that he will file the affidavit incorporating the same within a period of 2 weeks from today and prays for time. There is allowed. List this matter on 5th of May.
I mentioned this case from the foreclosure now. Already order has been completed.
Oh, yes, you said in the morning. Okay. So you have seen the order, right?
Well, I have this.
Declaration of service.
Yes.
Direction wise, you should to pass an order, my lord, regarding that has been rejected by speaking order.
That order has been passed.
That may be kept in mind.
But I.
This is a concept petition.
Yes.
This is a contempt. Paragraph page 13, para 8 is the direction.
A page.
Page 13, para 8.
Heard, Mr.
And Sharma.
N. Sharma, learned counsel for the petitioner, and Mr. Dina, learned senior government advocate, learned senior.
It's a contempt for us.
Oh, yes. Learned counsel for respond number 1, 2, and 3.
Lot.
The instant contempt application has been filed under section 11 and 12 of Contents of Courts Act 1971, read with Article 215 of the Constitution of India for alleged willful disobedience and deliberate violation of the order dated 27/1/2025, passed in writ petition number 5807 of 2023 by the Honorable Gauhati High Court. By the said order,
Para 8.
The matter is remanded.
by the said order dated 27/1/2025. The court observed that the matter requires that the matter be referred. This court had remanded back the matter to the respondent authority to re-examine the claims of the petitioner for regularization.
Yes, ma'am.
For regularization and thereafter pass appropriate orders, keeping in view the service book of the petition. Full stop. The direction was to be carried out within 60 days from the date of the receipt of the order. It is violation of this order that the petitioner has alleged in the present contempt petition. When the matter is called up today, the learned counsel for the petition has placed an order,
Respondent.
or learned counsel for the respondent, Mr. D. Nutt, has placed an order issued by Executive Engineer PWRD, Dispur and Dimoria Territorial Road Division, Pamani Model, wherein it is stated
Dated 16/8/2006.
next on the data that the petitioner, who was initially appointed as work charge roller handyman, was transferred and posted. No, was transferred in the year 1992. Was transferred and posted under the Assistant Executive Engineer PWD. And his service was extended from time to time. Oh, rejected.
It is rejected.
I thought it's a long term.
He has to challenge this order.
Then from time to time. Further, by the said order, it was decided that no more regularization of service of work charge, master row, or similarly placed workers can be undertaken by the state government. Even if such workers were engaged prior to 1/4/1993. Also, as such, the prayers, as such, the case of the petitioner was rejected for regularization by the speaking order dated 16/3/2026. In view of the said order, the instant contempt application is closed
With liberty to sue.
with liberty to file afresh with a fresh cause of action
Challenging this.
if any petition is dismissed. The order is kept as a part of the. Oh, yes. 34, Mr. Artishan, there, when leaving the court, said that the other department has to file affidavit.
Service of our respondent number 3 has been returned with eligible personal remark. May I pay for that's the step for
Not Mr. R.P. Sharma, learned senior counsel assisted by Mr.
D. Dole.
G. Dole, learned counsel appearing for the petitions. It is stated that service upon respondent number 3 is not complete, and as such prayer is made that the service of notice upon respondent number 3 may be done by Dustin. Prayer is allowed. The petitioner is permitted it takes to effect service of notice by way of gusty mode and file an affidavit to that effect. List this matter again on 24th of April. Mr. Varman.
Made to the motion. My lord, this, may I quick? My lord, before my learned friend submits, my lord.
Don't fight now.
Yeah, my lord. Just a small issue, my lord. I'm sorry, my lord. So he was excited anyway, my lord. Not a problem. So, my lord, the basic grievances are that, my lord, these are employees working under ASMB, Assam State Agriculture Marketing Board, my lord. They have been deprived of just a salary for last 11 months, my lord. So in between, my lord, what happened? Certain developments have occurred, my lord, and the salary that we are seeking for is basically lying intact in the accounts of the authorities because, my lord, a budgetary provisions and a process was followed. Thereafter, this amount was approved. Now, the only thing is that on the last occasion, this honorable court, because they were delaying in the matter, and on 31st of March 2026 is the last date, that is, my lord, coming week, when this fund will lapse. So what they are intending to do, my lord, we do not know, because on the last occasion, this court has given an order that you create a separate account safeguarding the interests of these petitioners, and that account will be basically an interest-bearing account. And if you delay, then the authorities will be, my lord, it will be on their part to pay the interest for the salaries that has not been released, my lord.
So why the salary has been stopped?
That is the crux, my lord, because they have not been able to come with a very definitive reasoning that why this has not been released, my lord. They come with vague ideas, my lord, like reasoning, like this board will be basically dissolved. They're planning to basically dissolve and give VRS. My lord, the aspect of VRS, they have filed their affidavit and have said that those who wanted to take VRS, they were given VRS. We are 136 employees still working in the office. We did not opt for VRS. So now the organization is working smoothly. Now what we are seeking is our regular salary. Now they have in their custody the amount which was allocated to us through budgetary the allocation. From that amount, we are seeking our dues. We are not seeking from somewhere else, my lord. This is, my lord, Assam State Agriculture Marketing Board, my lord. So we are employees of this board, my lord. But today I'm not pressing.
So as per last order, we have deposited the amount. So what happened? The marketing were earlier paid a salary to the employees from their own jobs, but after the commencement of GST, the entire sales collection has been stopped. After the government, that the cabinet decision been taken by the government to give VIS to the employees. But these employees, the 136 employees, they have not opted VIS. But as far as cabinet decision, the agriculture department have to take decision on regarding their continuation of service. That's the cabinet decision.
The authority has opened a separate saving bank account, bearing economy so. In compliance with direction of the High Court. It inside an amount of so. Only being area silence, therefore require the balance. So they have kept a separate.
Exactly, man. If he has an instruction,
we have to release 1 month salary to the.
They are paying us in peanuts, my lord. They are paying us in peanuts. For 11 months, we are not without salary. We have our school-going children. Man, who's going to pay for our fees, my lord? In today's day, my lord, for 12 months, people are not getting salary. It's not easy for them to run their families, my lord.
No, Lordship, there's a cabinet decision. After the cabinet decision, Lordship.
Cabinet decision to send them on VRS.
Yes, Lordship.
But they have not applied.
They have not applied.
No, he is trying to dilute, my lord.
No, I am not diluting, Lordship. We file a affidavit, Lordship, in this case, in the IL, Lordship.
So whether this matter can be disposed of today?
No, my lord. The lordship may take it up on Monday because I'm just humbly submitting, because, my lord, on 31st of March is the deadline for this fund which may get lapsed, my lord. Because there are other people, my lord, other petitioners also who have filed this case, my lord. On Monday, the other petitioners will be before this honorable court, my lord. Now, difficulty is that they will try to delay the matter after post 31st, because the entire, my lord, the effort of coming before this court will be, my lord, will become instructions, my lord. So what they are intending to do, my lord, I can very well understand, my lord, but I'm not on that. But I'm praying, my lord, let this matter be posted on Monday again, my lord. If it's not inconvenience for my lords. Till then, my lord, there is another set of petitioners who are coming, whose cases are fixed on Monday, my lord. So in that way, my lord, Monday will be a 30th. And if they are still reluctant to pay this salary, then, my lord, your lordship will take.
So Monday we will see.
Yes, my lord.
Lordship, we communicated the finance department for a clarification regarding the utilization of the, as per my line of consider, we have the money. But till that we have not received any
clarification from the finance department.
Budgetary allocation, ma'am.
Okay, we'll see, we will also hear what finance department is.
Yes, madam.
So finance
We'll
department
hear it on Monday.
Monday, madam.
finance department not different party loss in this.
Not necessarily, madam. A budgetary,
I will ask
So
you.
because FOC has been granted by finance department.
madam, a budgetary
There-
provision
there's a
under the assembly has been passed, giving us the allotted amount that we are entitled to. So madam, that budgetary amount, even finance department also has no authority because that is meant for us, my lord. How they are going to reappropriate the fund, reappropriation fund will be a different.
There's a provision for it, as per the budget group. We have planned it as per the department.
They are given as a grant to the board, and board has taken this money, has taken the money from the government as a grant for us, my lord. So that the small issue is that if the money has been given to us, my lord, why they are keeping this money in their own pocket and in their own accounts, my lord?
Pocket
No,
loss.
but then they said that there is a separate account and money.
No, so we have
Now, because this court has intervened,
That's what-
because this court has intervened on the last occasion, because they are trying to dilute everything and
No,
not
we
come
haven't
with
diluted
specific answers to the court. The court has given this direction that nothing doing. I will pass an order where separate account will be created. You do whatever you like on your part. I mean, Lordship, can you read the last one?
We have already complied this order.
Any parties? This matter again on
Monday.
this 30th of March.
I'm highly obliged.
Well, other petitions will also be
Yeah,
listed.
yes, my lord. These cases have been filed newly, my lord. They are going to be posted on Monday, my lord.
So all the matters will be taken.
Take care.
They know everything, but they are the capital system, they have not opted, we have lost it. And they are.
It is not compulsory retirement, my lord.
Clearly from this finance department, without finance department, clearly so we cannot release anything more. That's not our order. 2026, we have already cleared the account also.
On Monday, my
Let me
lord.
see.
On Monday. I'm obliged. my lord.
Yes, sir.
Lordship, IA is for the substitution of the original petitioner. They are the legal heirs. The original petitioner expired on 15th of October 2024. Lordship. So the legal heirs have been need to be completed, substituted because of the IA.
Sir,
AD Chaudhary.
AD Chaudhary and counsel for the petition. This interlocutory application is filed for substitution of the legal representatives of the petitioner who expired on 15/10/2024.
As petition number, page number 3. Lordship. Petition number 1.
The case of the petition, that is the original petition, that the respondent authorities have not released an amount of rupees 7 lakhs to the original petitioner towards his gratuity amount with the interest applicable at the rate, at the prevailing rate. The original petitioner died during the pendency of this case, that is on 15/10/2024, leaving 3 heirs. That is wife, daughter, and son. This is Mrs. Wilson, and looking at the advocate. Advocate Nirmal Saikar. No.
No.
As such, this application is made for substitution of petitioner number 1, or of substitution
Original.
of the son of the original petitioner.
Substitution of the original petition.
Substitution of the original petitioner by the wife.
Wife, daughter, and son. At page number 3.
By substitution of the original petitioner by the wife, daughter, and son. As applicant number 1, 2, and 3.
1 Roman 1, 2, 1 Roman 2, and 1 Roman 3.
1 Roman 1, 2 Roman, 1 Roman 1, 1 Roman 2, and 1 Roman 3. The application is allowed. What do you say? The substitute, the application is allowed, and the applicants are allowed to be substituted.
I is disposed.
Amended perspective.
And the petitioner is permitted to amend the course title and file the
Yes.
necessary.
Main case, Lordship, there is an order from Lavazima Court in the main case, Lordship. It was order dated 23rd of February, Lordship. According to the directed to take case step on the respondents, we have taken case step and it was supposed to be relisted before the Lavazima Court on 24th of March, but it was not listed. Lordship may direct to release before the Lavazima Court the main case.
In the appeal, petitioner I is disposed. In the appeal, writ petition, in writ petition, the office note reflects that notice to respondent number 2, 3, and 4 were issued by way of registered post with AD. But the same could not be served. And as such, the petitioners were directed to take fresh steps for service of notice upon the said respondent by way of speed post. And the matter was directed to be listed before the Lavazima Court again on 24/3/2026. As such, it is directed that the registry may list the matter before the Lavazima Court on 5th of April, on 5th of on 6th of April. Hearing matters will need some hearing days.
Lordship, Lordship, item 40, it may be 5th or 7th May.
Court master will be. Done for the day.